CEO of TBI, to give his wishes and greetings to the participants.
Good morning, everyone. Esteemed speakers, organizing committee members, participants, and all the members who are involved with this program. First of all, I welcome you all again to this program, 5-day national level program on patent filing process, patent application drafting and filing process. So if you look at the title itself, so you can see the amount of pain taken by ni-msme and then Mamta Madam for drafting the or for finalizing the details of this program. So they have covered right from drafting till the filing. So that covers entire thing till the claim constructions, how to defend yourself and all that. I think this is a golden opportunity which came to our doorstep for free. But generally, with anything which comes for free, we don't give much value. Please, I think this is a different scenario where please give a lot of value to this, respect the time of the speakers and other participants. And most important thing is, I insist that everyone should be on time. If you complete all other works, then if the time permits coming here, if that attitude is not there, even now people can stay back. But the sessions will start on time, and you need to, if you are interested in learning, because now if you see the government of India, Make in India, Viksit Bharat and all that. So all that is possible only if some new innovations come. New innovations come, it's of no use unless you protect that intellectual property. So as on today, at least if you ask me also after so many years of industrial experience and some limited experience in TBI, still I have so many doubts in my brain. All the dots are there, but I'm not able to make a rangoli, meeting all the dots. I'm sure that this 5 days program, I will also learn many things, and it will help for the protecting our innovation intellectual property. So with this, I thank the MSME and all the organizers for giving me this opportunity. And please ensure that you make best use of the time. The speakers are very much experienced and all that. So please ensure that all your doubts are cleared, and then it will really help us in the future. Otherwise, people who want to do innovation, they cannot do anything unless you protect your intellectual property. Thank you very much, madam, for the opportunity.
Wonderful, sir. Thank you so much. Your words of wisdom. Thank you. And once again, just one more small announcement. And all the participants will be having orange tags. So when you see orange tag, we presume that you are a participant. Okay. And these pink tags are the organizing committee members, so that you can identify who are all those. You have some issue or you want something to be resolved, you can meet the organizing committee. Whoever is having this pink tag, you can reach out to them. And secondly, the resource persons have a green tag. Okay, so you can identify the resource persons, okay, accordingly, and you can use their expertise, like not use, learn from their expertise. Okay, this is how we can, and we are being live streamed. Please ensure that, so that make your movement very restricted, unless and otherwise is very important. Please don't move here and there. That is one thing, because it is being live streamed. You know that, and there's been photograph, and your attendance is mandatory. Please ensure that we start the sessions on time, because it's first day, and there too we have to, without inaugural, we have to start with the sessions. So I just wanted to extend some greetings. And now I take this opportunity to invite Dr. Shanti to introduce our first speaker, Dr. Radhika Reddy. Yeah, please.
Dignitaries of the dais and respected faculty members and my dear colleagues. A very good morning to one and all. Now it is my privilege to introduce today's speaker, Dr. Radhika Mangala. Madam is presently working as manager IPR at BITS Pillani, Hyderabad campus, and she had been working as project scientist from 2023 to 24 at Patent Information Center, Telangana State Council of Science and Technology, and Madam had been working as NIPAM volunteer and further organized several IP awareness sessions. And Madam has also been working as assistant professor in chemistry from 2016 to 23 at St. Francis College, Hyderabad, India. And Madam had been working as woman scientist C and trainee from 2021 to 22 and as research scientist from June 2007 to December 2007 at Albany Molecular Research, Hyderabad, India. Coming to the education, Madam had obtained PhD in chemistry during 2011 and 17 and bachelor degree in science and computers during 2000 to 2003 and master's degree in organic chemistry during 2003 to 2005 at Osmania University, Hyderabad. And she had secured gold medal in 2006 for scoring highest marks in MSc Organic Chemistry and also won a cash prize of 25,000 awarded by DST for women scientists for clearing the patent agent exam in first attempt. And there are 50 patents filed with 5 granted and 7 designs filed with 2 granted, and there are 7 publications in reputed journals. Thank you very much, Madam, for giving me this opportunity to introduce Dr. Radhika Vangala. We welcome you, Madam.
Good morning, everybody. Thank you for the kind introduction. So, as Madam introduced, I'm the manager from BITS Pilani. So, I'll manage all the campuses, including Dubai, that is Hyderabad, Goa, Pilani, and Dubai. So, we do have recent campuses in Mumbai and Bangalore. Mumbai is functioning right now with SOM there, that's School of Management and School of Law. And in Bangalore, we are introducing recently, I think it hasn't come yet, the brochure and all, but there is a BITS launching in Bangalore as well. But Mumbai is functioning right. So we don't have an IP cell at Mumbai yet. Maybe in the future we may start. So I will tell you about BITS in the next session. During last slides, I'll present what exactly we do in BITS. But today, and I feel very elated when Sir said we are here to learn. So I'm happy that you have come here for learning something from us. Right. So I can see there are a few older people than us. So we are very privileged to teach you all what IP is. And I hope you leave the sessions enriched. So can I have the prop passed on, please? So I have some prop. Please do not eat from them. They are for viewing purpose. So view them, keep it in your brain so that I do have a slide for them. You will identify them and tell me whenever your chance comes. So please give it to the first participant and pass on the prop. Identify it, pass on. Do not eat them. Kindly do not eat them. That's what I'm saying. Do not eat them. Take the tray, see into this and pass on. That's a prop I'm using for one of my slides. So see what is there displayed, identify and pass it on to the next participant. I hope I'm clear. So we all know what, so don't look into the slide. I will ask you one question. What is a property? Don't tell me intellectual property. What is a property? Yes. So is this my property? Yes. So we do own properties like buildings, vehicles, other properties like, see, this is the property of Padmavati Mahila Vishwvidyalaya, isn't it? So everybody own their own properties. So these properties, we can touch them, right? So the properties which can be touched are called as tangible properties. And the properties which we own but cannot touch are called as intangible properties. Can you name, other than IP, can you name one property which we have but can't touch?
Okay. See, every session I ask this question, I'll get a new property, intangible property. So this one is the new. Yes, sir. Yes. The knowledge, intelligence, intellect. So that we have but we can't touch. The property which we own. So all the intellectual properties also come into the category wherein they are intangible. That means they exist, they are owned by us, but we can't touch them. So what is intellectual property? A property which we create using our intellect is called as intellectual property. And intellectual property rights, see whatever are, do we have passcodes on our phones? Why so? Why do we have passcode? To protect so that nobody else will steal the information in our phone, isn't it? We have the right to protect our phones. Okay? Here also, when we create a property using our intellect, we have all the right on that property and we have to protect them so that no one will steal the information. So the right on your property which you have created using your intellect are called as intellectual property rights. I think you got it. So these are the various types of IPR we have. Industrial property and copyright. I will let you know why we kept copyright aside. And under industrial properties, we have industrial design, patent, trademark, uh, geographical indications, and others like SICLD and PPVFR, which we won't learn them. Others are important. SICLD and layer semiconductor designs and plant varieties have come or introduced a little bit later, so they are not so prominent as the other IPs. So we will learn each one of them. By the end of this session, you will know all. So what is trademark, what is trade secret, you will know all of them. Have you ever seen this symbol anywhere? May I know where, please? Sorry? Websites, books, very good. And yes, very good, very good. So we see this C, of course not so big, but a little bigger than a full stop in all the websites. That means wherever copyright is involved. That means you are not supposed to copy information if the C is there. So if you have a habit of opening a newspaper early in the morning, this C will be there. You go to college, go to the library, open any book, this C will be there. That means you're not supposed to copy the information and say it is yours. Of course, you can copy, use it for other purposes, but you cannot claim it as yours and publish elsewhere. Right? Everybody has seen the prop? Yes. So this is for copyright. I'm not going to read out the information. I will just tell you that copyright is for all these works. That is literary, films, dramatics, music, and artistic and sound recording. So all these fields have copyrights. That means whenever you create something in these fields, okay, then you can protect them under copyright. I'll give you a good example. Say one of you is a poet and you have written a poem. What will you do? As soon as you write a wonderful poem, what do? You post it in social media, isn't it? Either Facebook, Twitter, Instagram, Snapchat, Telegram, wherever. Isn't it? You post it. And after a few days, say someone else has posted similar poem of yours uh, in their social media. So what do? You say, hey, this is my poem. I posted it long back and you copied my poem, isn't it? There comes the copyright, right? So why I have placed copyright in the other IP section, because whenever you create something and release into the public, post it at least on a paper, in a newspaper or any social media or even in a WhatsApp, you have the proof that poem is yours and you have published it or you have written it before someone else has posted it. So if you have that proof, then you can ask that person to move back and remove that published, whatever he or she has published. But if you register that poem as a copyright, then you have the chance to take that person to court. So that is the difference between other IPs and copyright. You don't have to really register for a person to back off. But if you have to fight in a court, then you have to register the copyright. Otherwise, you don't have to register the copyright. Once you create something, copyright is already created for that work. Clear? So there is a concept called as fair use concept. Yes, sir. It's up to the organizer's decision. But if you have, please. Yes. 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 No, you don't have to register, sir, but it should be in the public domain. That means this person has released this. For example, if you publish an article in a journal, that is in the public domain. So you have a proof that your work is published. But if you keep it for yourself, you write a poem on a paper, keep it for yourself, then nobody will know that that poem is written by you. Though you put a date and so, nobody will know. So it should be in the public domain. Then only copyrights are created by themselves. But to take a person to a court, you have to register it. So all the slides which I am using, I didn't create them. I've copied them from somewhere else. So can I be taken to the court? Because I'm presenting here, you're listening to me. I can say this is my PPT. All the slides are mine. So can I be taken to the court? Yes. So you all know me. You all know this before. So there is a concept called as fair use concept, wherein fair use concept says that if that content, whatever you are copying from anywhere, you are using it for educational purposes or research purposes. I have a very good slide in the in the coming few minutes wherein we will know. Okay, so if we are using it for research or educational purposes, then that is not copyright violation. You can use fair use. That is called as fair use concept. So you are not commercially exploiting. If I sell this PPT to uh, university for so and so rupees, then it is commercially exploiting because this is not my PPT. I have copied it from somewhere else, right? For example, I'll give you a good example in your own language. Your professor asked you to prepare a PPT for so and so topics. We give assignments to the students, right? So we give assignments, ask them to prepare a PPT, come present, and so that we'll give them the assignment marks. What do the students do? They don't prepare their content on their own. Go to SlideShare, download the PPTs, modify a bit, and then present it to your professor, isn't it? So the content is not created by you, you're copying it, right? So are you violating the copyright rule? No, you come under fair use concept. Though you say that PPT is yours, you didn't create it, but still you're copying it for educational purposes. So no harm in using that, right? I'll give you a good example. Say I own, for example, I have subscriptions to Amazon Prime, right? So there is a recent movie released, say Netflix. Okay, I'll take a good example. Netflix. Recent movie Pushpa 2 is released in Netflix. Okay, I will watch fair use, right? I don't have enough time to watch all the 3.5 hour movie at a time, so I'll download the movie, watch it whenever I'm free. Fair use because I'm paying for the Netflix subscription, right? I'll call my friend Swapna madam to come. Yes, madam, we will watch the movie together. I'm bored watching alone. I'll call her. We will watch together. Fair use because I'm sharing with my friend. Okay, I'll call all of you. Play the movie here. Take 500 per head to watch the movie. Not fair use. Okay, not fair use. That is not fair use because I am commercially exploiting. Okay, this is fair use concept. I have a good example for that. I don't know how many of you know this. Have you ever seen this? I mean, what do you mean by infringement? Have you ever heard this word before? Yes. What do you mean by infringement? See, there is no need to explain infringement, but if I explain infringement, you will understand the topic more better. So, infringement is nothing but stealing, trespassing, copying. This is a simple English word. Okay. So, good example for fair use concept. I don't know whether you know this movie because in Telangana it is very famous. Yes, you do know. Balagam, This is a movie which is released last year in OTT. That means Amazon Prime. It is released. So this Balagam movie is about family bonding and all. So in this movie, it says family is important, and in the end, the family will bond. So what happened is produced by Dil Raju. So this movie was what should I say? A sarpanch from Sirikonda village of Nizamabad district. He was touched by this movie, and he wanted all his village people to watch this movie. So what he did is one fine day he invited all the village people to watch this movie which is being played on a very big screen. Of course, the sarpanch bought a subscription of Amazon Prime. So what happened? All the village people watched this movie, and in the newspapers there was a big poster of the sarpanch praising him that the sarpanch is a big man. So for his village he did so and so. And what then came the police officer. He was arrested because copyright infringement. Okay, copyright infringement. He is not supposed to show the movie to so many of them. So though he has good intentions, though he did not take money from all the village people, he was arrested on the basis of copyright infringement. Because see, there were around 100 to 200 villagers maybe, or even more, but I'm taking 100 to 200. So maybe I am one of the villager. So somebody said Balagam is a good movie. So I'm thinking of buying an Amazon Prime subscription tomorrow and watch the movie. My Sarpanch gave a free access today. So why will I take a subscription tomorrow, unnecessary subscription, paying so many hundreds or thousands of rupees, isn't it? So what is happening here? Amazon is losing one subscription from me, and Dil Raju will be getting from that subscription some amount, some percentage, isn't it? So both are at loss. Do you agree? So what happened? So this Sarpanch, since he showed to thousands of people, he is creating that loss to both these persons, producer as well the Amazon people, right? So Sarpanch was sued. Then he has to plead, beg, and I think the case was settled outside the court, this infringement case, because the Sarpanch was not aware of copyright. Okay, copyright. Bits also, we play movies on every Saturday or Friday night in our amphitheater, but we do have copyrights. We take copyrights and then we play the movie for all the people residing in our campus. We all have all the campuses of Bits are residential, so we play movies. We matlab the management. I hope you understood the fair use concept. So can you tell, this is a copyright infringement case. Can you tell me what is the copyright here? Yeah. The movie is nothing related. Both Hulk and Gajni are not related in anything at all. Both are different movies. But still there was a copyright infringement here. Yeah, the style of presenting the poster. Okay, the style. It was copied. So there is a copyright case between Hulk and Gajni. The Hulk people sued the people of Gajni by using the copied poster. One more example of the same. Even there was a copyright case between these two movies. Presentation of poster. I hope we know both the movies, Magadira and Rabta. So the producers of Magadira sued the producers of Rabta because everything was copied. The storyline, the anti-heroes, everything, the reincarnation part, everything was copied. There was a very big copyright case in those days. Of course, later on it was settled outside the court. I hope everybody knows this. So, if you have watched this Kantara movie in the first 2 weeks, this Varaharupam song is muted. Why? Because there is a band called as Saikudim Bridge from Kerala. They said that they created this Varaharupam song. I mean, the music, lyrics, and all are owned by them, and this Kantara people copied. Okay, so there was a that song was muted for 2 weeks because the case was in. I mean, the movie was involved in a copyright infringement case. So later on, they settled the case. I mean, I think some royalty was paid or something like that happened. And after the second week, the movie in the movie the song was unmuted again. So this is also a big copyright infringement case. How many of you know this? I could see smiles on your faces. May I know why? See, I use this, and I download around 1,000 articles daily from this site. Is it legal to use this site? Is it legal? Say, I'm using, so don't worry. You can say yes if you are using. So, is it legal? No. We all know that it is not legal to use Sci-Hub, but we still use Sci-Hub for downloading the articles which are, yes, which are not available for open access, which are chargeable but free in Sci-Hub. And are we paying anything for the Sci-Hub? So there is a big copyright infringement case on Alexandra, the owner of Sci-Hub, by all the the editors of big journals like Science Direct and other editors, Springer. They all sued her, who is the owner of Sci-Hub. And you know what? She is defending her case till today. Can you tell me on what basis? By now you should be able to tell. Yes, ma'am? I need that one word which I told. Very good. Fair use. Fair use. See, are you paying something to Sci-Hub? Isn't it? So, she is still defending today in the court that my Sci-Hub is for fair use. That means she is using for research and educational purposes, wherein you don't have to pay. Those are available for free, and she is not gaining anything commercially from us. So, it comes under fair use. One more, last one under copyright. So, if you are a voracious reader of newspaper, this is published around 3 to 4 years back in one of the newspapers. So, monkey selfie case. And before exactly diving into that case, I will tell you a small story. So, there is this photographer, wildlife photographer named David Slater, who is taking pictures, okay, in a forest. His assignment. Okay, he is taking pictures, and when he was clicking, he observed that some monkeys were observing him. So he got an idea. He placed the camera and then went and hid behind a tree. So one of the monkey came and randomly hit the camera. So one of the picture was like this. It is like a monkey taking a selfie, and this is like 4 to 5 years back. See, 4 to 5 years back, selfies were coming into the picture. Those days, selfie is a normal thing which I wasn't able to take, but monkey taking a selfie is a crazy thing in those days. So he published this in the journal. So he earned millions of dollars from this picture because monkey taking a selfie is a crazy thing. So he earned millions of dollars. Then come back. So this is my mobile. Okay, who owns this? Me. Okay, and I'm a very bad photographer. I'll take you. So let's go take some pictures. Okay, let's go and take some pictures. The sunset or sunrise in the university are really good at a particular place. So both of us will go and take pictures. So I will take really bad pictures, but she is a very good photographer and she knows how to tilt the camera in a particular angle, light and also she takes really good pictures. And I post it in my Instagram. So does the photo belongs to me or her? No. So, no. See, though I own the camera, I told you I'm a bad photographer. She is using her skill, her intellect. So the pictures belong to her. Though the device is mine, the pictures are hers. See, if you have seen the Instagram profiles of celebrities, whenever they post a picture, they write PC. What is PC? Picture courtesy or photo credits, because if they don't write they will be sued under copyright by the picture who has taken the picture. That is why they clearly mention PC and write the name of the person who has taken the picture. So they give the credit to that person because they will be sued for copyright. Now who owns the picture? She owns the picture in my mobile. Now come back here. Who owns the picture? Monkey. So the PETA people came with this logic. Who are PETA? You all know, people for animal ethics. Okay, they came into picture. They sued David Slater and said, how did you earn so many $1 million when the picture doesn't even belong to you? The picture belongs to a monkey. You shouldn't own the dollars, isn't it? The dollars belong to monkey. Later, he is a small photographer. How will he pay or how will he fight against the PETA people, isn't it? So, what did he do? He hired a good attorney, maybe like us. Okay, he hired a good attorney, and the attorney says, see, the case was closed. So, the defendant, he defended himself saying that, see, monkey is not a human being. Okay, it doesn't own intellect. Intellectual properties are only for those who has intellect and human beings. So, PETA people, see, PETA people are bigger people who have bigger attorneys. But this simple statement, David Slater won the case. But till today, he is donating 10% of the income earned from that picture to those genus monkeys. So this ends the copyright. I hope you all understood the copyright. Can we all tell them what are they? What's the first one? You can shout, no issues. Android. Second, Apple, McDonald's, Windows, Coca-Cola. That is Coca-Cola. Second row, first one, Shell, CNBC, Olympics. Yes, very good, sir. Target. This is a shopping mall. Target and Mercedes. Third row, first one, Pepsi, Pillsbury, Disney, of course. What's the special character? Mickey Mouse. Mickey Mouse, Superman, Nike. Arey wah. All of them are perfect. So, I am wondering, are the teachers teaching you these things in the classrooms? Yes, ma'ams, are you teaching these things in the classrooms? See, you may not get 100 out of 100 in the test, but how come you could recite all of them 100%? Not even a one you missed. Everything you said, isn't it? How? And did you observe? I didn't even write the names. For Nike, there is just a tick mark. There is no Nike, but still you said Nike. How? Used brands, they are all called as trademarks. Okay, trademarks. So, why trademark? Why trademark? Because if you have a trademark, it defines the quality of that particular brand or product. Okay, trademark is for quality, right? So a trademark can be a shape of the bottle, name, logo, slogan. Like if you see the slogan of McDonald's, I'm loving it. Okay, that slogan is a trademark. You cannot copy that slogan to something else. You cannot put a slogan, I'm loving it, for a cloth store. Of course, you could have, but since it is already used, you cannot. And the M, that is a simple M, but you still identified it as a McDonald's M. Hyderabad Metro is also M. See, there are more than 2000 trademarks on just the letter M. More than 2000 trademarks. So you can imagine how an M is written in 2000 ways that you can identify or differentiate. Then the color is also a trademark, and of course the logos. So trademark is nothing but it defines the quality of the product or service offered for any goods. And I want you to identify this. I'll play something with the organizer's permission. Yes, yes, sir. Very good, very good. One more. Very good, very good. Many cases nobody will identify this. Yes, the Airtel Music and the three tins of Britannia are audio marks. They are also trademarks. See, nowhere in the music it was told Airtel, but still you could identify. And the three tins of Britannia, it wasn't told to us that it belongs to Britannia, or there was no pronunciation, but still you could identify it belongs to Britannia. So these are all audio marks, that is nothing but a part of trademarks. We do have service marks also. And very recently, they were talking about smell marks. They didn't come into the market yet, but smell mark also is there. I don't want to read this. Yeah. So a trademark infringement case between Paytm and PayPal. Paytm we use, it's a Chinese company. PayPal is a US company. It started as a copyright infringement case, then converted to trademark. Why? Can you identify why it is a trademark infringement? Yes, the color used in the logo. Both of them are blue and light blue shades, and the pay word. Pay word we can say copyright, but the color they used belongs to trademark infringement. We all usually see in small stores how they copy the logos, brands and all. So this is a very recent trademark case which won around 4 crore rupees. That's a very big amount in the recent times. So this camphor cone was a product. I think all of us know about this camphor cone. We use it as an air freshener in our cars. So Patanjali copied the camphor cone and started producing the same thing. So this camphor cone people sued Patanjali, and Patanjali has to pay 4 crore rupees to them because they did a trademark infringement. This case was won very recently, few months ago. So this is about trademark. I hope you understood. So what are the two IPs we've learned till now? Copyright and trademark. Very good. Now the third IP is trade secret. So trade secret law is not there in India yet. Not there yet. But other countries follow this trade secret law. Okay, we have this, what is this? Information Act, RTI. So other countries, I don't know about other countries, but still, because of RTI, I think the trade secret is not coming here. So what is trade secret? Something you prepared. Okay, something you prepared wherein some ingredients you used, okay, and you don't want the other person to know, and you want to make a business out of that product. Then you can file a trade secret for that. Don't even have to file. You can maintain it as a trade secret. If you don't tell anyone, it's a trade secret. So trade secret can be a recipe, a design, a formula, and anything. Okay, pattern, anything. The business you make out of it. So the recipe or the information behind it can be kept it as a secret. Nobody will ask you to reveal the trade secret or the secret behind that recipe. The good examples for the trade secret are the recipe of Coca-Cola. So it is a trade secret, and the chicken of KFC, the sauce of McDonald's, these are all trade secrets. You will not ask Coca-Cola people their recipe. If you have had all the drinks, sodas in the market, none of the sodas will taste like Coke. See, if you see, what is this, Sprite and 7 Up, they both taste similar. Okay, just the brand is different, but Coke, it is unique. Though you drink Pepsi, Pepsi taste is different from Coke. So Coke has their trade secret, the recipe filed as trade secret. And even the chicken of KFC, and see, if you try to make a KFC chicken, will you be able to make? Nobody can replace that taste because it is a trade secret. And how many of you like Google? Google search. See, my phone has Safari, my laptop has Safari, my office desktop has Bing. But still I crave Google. I use Google only. Google only. Why? User friendly. That's all we need, right? See, I'm not degrading anything. In the Bing search, if you give something, you will not get 100% satisfactory results. It will give maybe genuine results, but it is not up to my. See, very recently I was searching for flights to come to Tirupati. Google gave me good results than Bing. So that's a very good example, isn't it? So Google search is a very good search engine. So the algorithm of Google search is a trade secret. That is why nobody could copy the Google search. Okay, Google search, and no search engine is as good as my personal opinion. Okay, don't jeopardize this. All right. So no search engine is as good as Google. So Google search algorithm is a trade secret. That is why I think nobody can, go beyond this. right? So this is about trade secret. Since we don't have it in India, we don't have to learn about it, but just for your information purpose. Know it. That's it. So 3 IP is done. Yeah. Now coming to the prop I used. What are all those? Can you please tell aloud? Good day, little hearts, hide and seek. Perfect. See, all those biscuits are given without the trade dress. Trade dress means the outer cover. That's also a trademark. Can you tell me what is the colors used for trade dress of Dairy Milk? See, Kit Kat, red. See, that is trade dress. That's also a trademark. Okay, coming back to here. So, why did you identify the biscuits even though they are not in their trade dress? Design. I want that exact word. Design. Because of the design. See, if you take good day, okay. Why did you say good day? Because there is mom's magic as well. Mom's magic also has similar taste. Everything is same compared to good. But why did you say good day, not mom's magic biscuits? Mom's magic shape is also circle. Yes, the curved line. It's their design strategy. Mom's magic has straight lines and a heart in between. Okay, but here they have curved lines. Smile, the smiley. That is their design strategy. And if you see little hearts, heart shaped biscuit. If you go to any supermarket, not roadside peddlers, okay, go to any supermarket, you will not find any heart shaped biscuits. I can assure you that. Next time you go to a supermarket, try finding a heart shaped biscuit other than little hearts. That is their design strategy. And what is hide and seek? Hide and seek. The chocolate chips are hiding inside a biscuit. You have to seek them while eating. That is their design strategy. Hide and seek. Okay, hide and seek. So, this is about industrial design. See, many have a misconception. Many of them say, see, they will call me, Madam, I want to file a design patent. There is nothing like design patent. Only ignorant people say design patent. At least in India, there are no design patents. We have industrial designs, we have patents. Don't club them. Design is different, patent is different. Both are different IPs. Okay, so design is nothing but industrial design, which can be given only to the outer appearance of any product. If you see, those are good day biscuits. And the next one is a design as well. What is the next one? It's a Coca-Cola bottle. See, all of them used to come in these glass bottles. See, there are glass bottles for Mazda, Pepsi, everybody. But how did you say this is a Coke bottle? Shall I tell you why? The Coca-Cola bottle, what is the color of Coca-Cola? Wine. Okay, wine color. When the Coca-Cola bottle is filled, it appears as if a lady wearing an evening gown. The shape of the bottle of Coca-Cola is designed such that a lady wearing an evening gown. That is the design strategy. Next one. Yeah, evening gown. Because it is wine colored, right? Evening gowns are usually black and wine color. And what's the next one? What shoe is it? Which? No. So it belongs to Christian Louboutins. Okay, Christian Louboutin is a very famous Paris company which designs shoes and bags. Their design strategy are all the shoes, stilettos, everything. They have red soles. Red soles. Inside, if it is a shoe, inside the shoe is red in color. If it is a handbag, inside the handbag is red in color. So this design strat is there is nothing designic here. That's just the red color. But this design they own it. That means the red soles inside part is red, owned by Christian Louboutin. This is their design strategy. Usually all kettles are hexagons. There is an octagon kettle, unique. Okay, unique pattern. That is why it comes under design strategy. The chairs, everything can come under a design strategy. Even the mouse. We can also register this mouse if it is unique, not a regular mouse. If it is unique, we can register under designs, right? So all the if you go to a jewelry shop, a branded jewelry shop, say Tanishq and all, and you see a good diamond jewelry set, will you be able to take the picture of the diamond jewelry? Will they allow you? No. Why? Because all the jewelry sets are registered for design. They have might have applied for the design. Until it is registered, they will not allow you to take the picture. And Manish Malhotra, Sabyasachi, Ritu Kumar, all these people, they register their apparel, jewelry for design application. Hero Honda, I mean all the car companies, everybody register for designs. See Tesla, what is the design of Tesla? Tesla car. As soon as you see a car from a distance, you can say it is Tesla because the design is little different. From far, though you cannot see the logo. Of course, with logo we can identify, but with the car design, yes, it is Tesla. Okay, so that is their design strategy. This is industrial design for you. I hope you understood. It is a 3D aesthetic part of any product. Any product you can apply for design. Yes. What is the first one? I hope I don't have to ask. Tirupati Laddu, second one. Pochampalli Kath, third. Kondapalli Bommalu, fourth. I mean first one, second row. Bengali Rasgulla. Next. Guntur Karam, Hyderabadi Halim, Bandar Laddu. Ma'am got it. Bandar Laddu. Yes. Madurai Malli. Are you a Tamilian? Madurai Malli. Madurai Malli. The jasmine is very famous over there. If you go to Madurai, everybody will sell the Malli on the streets because this is very famous there. And the last one, Charminar, Lac Bangles, and that one is, of course, Mysore Sandal Soap. Except Mysore Sandal Soap, I haven't written anything anywhere. Don't tell me this is trademark. No, this is not trademark because trademark is a logo or a strategic design. There is no design or a logo, nothing. But you identified Tirupati, Pochampalli, Kondapalli, Bengal, Hyderabad, Guntur, Bandar, Madurai, and Hyderabad again. So what am I insinuating here? Very good. Geographies. Okay, geographies. That means these are called as geographical indications or indexes. Anything you can call. Okay, geographical indication is nothing but this product is famous for that particular geography. Okay, can you tell me some more examples? I've given you a four. Few. Can you tell me more? Agrakapeta, Atreyapuram Putarekulu, Kakinada Kaja, very good. Yes, chicken curry, yes. Yes, banana chips Kerala, Darjeeling tea, very good. Yes, very good. Kalamkari. Kanchipuram, silk saris, very good. Yes, Uppada, yes. And very good. Mangalgiri Pattu. And Banaras, yes. Jaipur, yes. Kolhapur, Chappal. Jaipur food, no, I don't think that is registered for GI. Yes, Kashmiri Pashmina shawls. And I mean, India had more than 500 GIs registered. Okay, the GI came into existence from 2005. India has more than 500 GIs registered till today. And that's all. Yes, Araku Valley tea. Yes, very good. Tanduru Red Gram is the recent, I mean, last year, 2024 March, we got it. Telangana got it. Kashmiri chili, yes. Kashmiri chili, Guntur chili, Varangal Chapata chili is the recent one also. Varangal Chapata chili. We also applied for Nalgonda Doskai, Balanagar Custard Apple. They are in progress. The recent one being the Charminar Lac Bangles. 2024 December or November. Charminar Lac Bangles, we got it. So these, Hyderabad biryani, no. Because there was, see, it was registered and then denied because many of them fought. See, we make biryani. See, geographical indications are for those people. It is not given for a single person. Geographical indication is given by for a community. So you have to make a community come and ask for a GI, place a GI in front of the government. Then it will give to the community. So Halim, if say Hyderabad Halim is given to Halim makers of Hyderabad. Okay, so for this Hyderabadi biryani, many groups came and we wanted, they fought and they denied. So we couldn't get it for Hyderabadi biryani, though it is famous, we couldn't get. So we can talk about basmati rice in the next session, afternoon session. I have a slide for that. So these are geographical indications, and tell me why these are famous. For example, you said Araku Valley tea. There is Darjeeling tea, there is Assam tea. All teas are registered for geographical indication. So, why there is a geographical indication for tea at three different places? Taste. You say that taste is different. Why? Why do you think so? Flavors. Yes. Why the flavor is different? Can we grow saffron here? Kashmir saffron. Why? Climate. The climate of Araku, the climate of Darjeeling, the climate of Assam is not same. Okay, it's not same. So the taste of the tea is not same. Okay, the taste is different because of the climatic conditions and the soil of that particular region. That is why we call geographical indication. See, geographical indications can be two types. One is man-made, one is natural. Natural as in tea, the mirchi. Man-made, yes, the flowers. Man-made are the lakh bangles, halim, bandar laddu. These are all man-made. So geographical indications can be man-made, can be natural, right? But belongs to that particular region. See, I cannot make Tirupati laddu at home and say this is, maybe I can get the same flavor, same taste, but I cannot say this is Tirupati laddu, right? Maybe I can prepare the same thing. I cannot prepare halim in my home and say this is Hyderabad halim and I can sell the halim. No one can sell Hyderabad halim unless you are an authorized user in the GI registry. To sell Hyderabad halim also, to sell Bandar laddu also, you should be the authorized user elected by GI registry. You have to register as an user, then sell Bandar laddu. So the association will grant you the usership. You have to pay 500, that's it, and register and then prepare Bandar laddu and sell. You can do that, right? So this is GI, but why GI? Why do we have to go and take so many pains to register the GI? Why? Because it will help us in getting the rise in the economy of that particular region. So I've taken a good example here. This is Kadaknath black chicken of Madhya Pradesh. Okay, so this black chicken is entirely black. The meat is black. Okay, the meat is black. The eggs, the hen lays are also black. Very rich in melanin content and highly nutritious. So before they registered for GI, the meat was 500 per kg. Now, after they got the GI, the meat went up to 1000 rupees per kg. So, this is GI. That is why we have to register for GI. So, recently Modi ji also, when he goes to different countries, he will carry our GI products. So, yesterday I am reading the news. Naga Chaitanya and his wife gave a Kondapalli Bomma to Narendra Modi ji. That's a GI. And our Chief Minister, Mr. Revant Reddy, when he went to Davos, he took all the shawls of Ikat shawls, Pochampalli Ikat shawls and other GIs from Telangana region and he gifted to the dignitaries over there. Can you name some worldwide GIs which are famous other countries? Yes, Swiss chocolates, champagne, French wine, champagne. These are all some watches. These are all some GIs of other countries. Of course, we are concentrated only on India, right? So this is about GI. Yeah, and this is the logo of GI. So there is an interesting little two-line story here. So here, when Modi ji came, so he has seen, so he is mainly concentrating on IP. So when he came, he introduced a ideathon, ideathon to get a logo for GI. There wasn't a logo for GI. So Modi ji conducted a ideathon. Do you know what is an ideathon? You will get a QR code. You have to design the logo and send it to the QR code. You have to, of course, fill all the forms and all, send it to the QR code. From your home you can play the ideathon. Your idea you can send it through QR codes. That is ideathon. We are conducting, bits also conducts hackathons, ideathons. We do that. So they conducted ideathon so that everybody will give their ideas on the logos. So one engineering candidate, so he designed this logo for GI. And if you see the tagline, Atulya Bharat ki Amulya Nidhi, invaluable treasures of incredible India. So this was selected and he was given a very good amount of cash prize. So this was from a student, the logo as well as the tagline. Coming to the last topic, patents, my favorite. So can we recall what all we learned? First one was copyright. Second, trademarks, industrial design, geographical indications, trade secret. That's all. We completed industrialist. And last one is patents. I hope when someone asks you after you go out, what is the IP in this? I hope you will be able to tell. Now, let me show you something. Yeah. What is the IP in this? You should not tell, after the session you will not tell logo. What is the IP in this? Oh my god. Yes, this is a trademark. Okay, trademark. If I ask you this, you should say it is design. The design, how the camera lens are placed. This is the logo here. So this is a trademark. Right. Now coming to patents. What are patents? Patents are nothing but, see, I will define it in a few words. Patent is a techno-legal document. Okay, techno-legal document. Techno means because it has all the technical invention embedded in it. For that only we are getting a patent. Legal because we have 162 sections in the Patent Act and few rules as well. Okay, so that is why legal things are involved. We call it as a techno-legal document. Patent, we get a grant certificate that is called as a techno-legal document. And why you see, patent is called as a negative right. So when we define patent, okay, a patent is something you will stop someone to buy, sell, import, and so on. That is patent. So if I see this, it's a monopoly right. See, whenever you write patent, first we write claims. Okay, in that claims we say I claim. If I am the whole and sole applicant, I claim. If there are more than one, we claim. Okay, that means monopoly. Hitler, you are giving the entire rights to that particular person. That is why we are creating a monopoly there. Negative right, the definition of patent itself says it is to stop someone to copy, sell, buy, import the invention you created. When we are using this, all the rights in the constitution are positive rights. Only patent is a negative right because you are stopping someone to use your invention. That is why it's a negative right. And statutory, of course, since legal things are involved, statutory. Territorial. What do you mean by territorial? Belongs to that particular country or region or jurisdiction. In our language we call it as jurisdiction. Okay, in that area, right? So when you have an invention, you file an Indian patent. I say you have a patent for a paracetamol tablet, say. So I cannot make, sell, buy, import a paracetamol tablet in India, but I can copy your invention, Go to US, go to US, open a big industry and synthesize paracetamol, sell. I can sell. I cannot file a patent, but I can sell the product. I cannot sell in India, but I can sell in other country, other jurisdiction. So that is territorial right. When you have a patent in India, you have rights only in India. If you want a right or patent in other countries, you have to file differently. Or we have other methods. Maybe you will learn in the due course, like PCT and convention methods, wherein you can file in all the other countries at a time. And remember, there is no word like international patent. There is no word like world patent. No. Okay. No patent is international. No patent is world patent. Only territorial patents or PCT or convention. Wherein in PCT we can apply to many countries at a time. Right? What is this? Can you know? I mean, do you know that there is a patent on that? There was a patent on that paper clip. So it is in the year 1934. There was a patent, such a small thing. Okay, such a small thing. Paper clip. We use the gel clips we use to stack the papers, isn't it? There was a patent. See how beautifully it was written in USPTO, United States Patent and Trademark Office. The post-it note. The post-it note was also a patent. If you read the title, see, repositionable pressure sensitive adhesive sheet material. They didn't say post-it note. See, repositionable, that means we can place anywhere we want, and adhesive pressure sensitive. With pressure we can remove or place. Pressure sensitive adhesive sheet material. It's a paper sheet. See, for a post-it note, that's the title. That was the title they used. There is a patent. There was a patent on the post-it note, I think in the year 1993. So after 20 years, of course, the patent will be dissolved and we can use it in the public. Velcro. The Velcro also, they didn't name it as a Velcro. The patent was named as velvet. Okay, I can't really look into that. So there is a patent on Velcro. See how beautifully they defined the Velcro. So they said that there are hooks and loops. When you close it, the hooks will go, and if you read the patent, you will get to know. The hook will go and bind to the loop. When you open it, the hook will de-entangle from the loop. That's the functioning of Velcro. So very beautiful patent. You should read it actually. Then there was a patent for light bulb. There was a patent for traffic lights by Morgan. There was a patent for pencil with eraser, and dual-headed pencil. See, when pencil came, nobody knew other side also they can sharpen right. So there was a patent for the other sided pencil also. See, just a small invention and a little modification to it, it became a technical advancement and a patent came. Fountain pen was a patent. Yes. Coming to the term and whether we need registration of the IPs we have learned until now. So patent term, as I said, 20 years and registration is compulsory. Say today I am filing a patent for Velcro. After 20 years, the patent will be mine. I can sell, use, I can stop someone in selling, using, buying. Okay. After 20 years, it is free for public. I mean, I will not have that right. Of course, grant will be there, but after 20 years, that will be in the public domain. You can use it. Okay. Then copyright. Copyright, when someone creates a copyright, it will be there for lifetime. After I say I have composed a some music. So that will be there until my last breath and also 60 years after I die. So the income generated from that will go to my legal representative. Okay, lifetime and 60 years. Trademark, when a trademark is created, you have to, and copyright is optional as I said. If you want to take it to the court, better you register. If you don't, but you don't have to really register a copyright. Then trademark, 10 years registration. After 10 years, you can renew for every 10 years. Designs, Registration is mandatory, 10 years plus 5 years it can be extended. Trade secrets, as long as you keep it secret, it is a secret. No registration, because once you register, the secret is out. So no registration for trade secret. Of course, we don't want integrated circuits. Geographical indications, similarly 10 years plus every 10 years renewal can be done, and registration is mandatory. So these are the terms of various IP and whether registration is mandatory or not. So I've done a small search for you guys. So how we exactly do. So my search item was herbal mixture for diabetes. So I'm relating invention or innovation to the patent exactly. See, some may feel in their labs, my invention may be not so what should I say, great one to go for a patent. So don't feel, I have taken such simple examples such that you will not go back and say my invention is not good enough for a patent. So see these inventions. See, after seeing the post-it note, paper clip, you should be able to tell my invention is a very great invention, because those are also simple and silly inventions, but still they were good patents. You know what? Do you drink sodas from tins? Tins. So the soda tins have the opening mechanism of that some thin material that was a patent. So one person, he invented it and he got a patent registered. He went to this Coke company and said, I want to sell this to you. They said they will give tenth part of the cent. That means 10 paisal for one usage. ఒక్క can కి అది యూస్ చేస్తే they said they will give 10th part of the cent. That means 10 paisal in our this thing. So that person earned millions and billions of dollars per day, more than $500 million per day, only on that small can opening thing. Yes, the which you rotate and open it. I don't know what you call it. So coming back, herbal mixture for diabetes. So here, when I did the search, you can see 65 results are there. So this is the WIPO site, patent scope site, wherein we do free search. Anyone can use the search engine. So patent scope, WIPO, WIPO, it's a WIPO portal wherein we use it for free searches, patent scope. So I got 65 results. That means there are 65 patents on a simple search string, that is herbal mixture for diabetes. So if I see the search, first search is a Russian patent. Okay, Russian patent. In that diabetic mixture, they are I didn't highlight that, but they used, see if you can see all the oregano, some sage leaf or some dog rose seed, some they have used. I want this exactly. Somewhere it is, I think, cinnamon say, and then see the next one. Second one is an Indian patent. Yeah, Indian patent. See, they are using Sycesium cumini. That means jeelakarra, the cumini. And if you see the third one, that's an Indian patent again, a different one. They are also using cumini, the same ingredient. The same ingredient we have seen in 2 consecutive patents. Okay, so all the patents will have similar ingredients. Say I am preparing a diabetic mixture today and I'm using all the ingredients same to the patents which are already there, and I'm using an extra ingredient, say kala jamun mixture, and telling my mixture is more efficient. You have to prove the efficacy which is already there in the market, then you will get a grant. It's not that your mixture is same. Okay, you have to prove the efficacy of your invention so that you will get a grant. Don't worry that since it is already there in the prior art, you will not get a patent. Prior art is nothing but which is already there in the market. That is prior art. So don't worry that your invention will not be patentable. Go to a patent attorney like us. Come to us. We will do the search whether it is there. If it is already there, everything is there, we will tell you how to modify your invention and go for a patent. Okay, so you can go for any simple invention. You know what? Very recently, a housewife got a patent for an idli batter mix. She prepared an idli batter and that batter stayed fresh for 60 days and she got a grant for that. So you don't have to be a inventor or a scientist to get a grant. any person can get. Okay, next session also I have few slides. The significance of patents. Okay, only the people working in the lab will get patents. No, nothing like that. Anybody can get a patent if you have solid invention in your hand. Right? Yes, ma'am. Ma'am, wait, sometimes prosecution will be tougher for us. Ingredients, it would be better to fight. So prosecution will be easy for us. Weights, yes, sometimes, but if you just change the if you change the ingredient also, ma'am, the ingredient should be efficient enough. Just for example, if you just simply change a salt, sugar, add it, say this is the invention. No, you have to add a solid ingredient so that you support your invention. That your invention is more efficient than the ones already existing. Or yes, you can also go for concentrations, lesser concentrations, more effect. Yes, we can get a patent. See, they are using 10 grams. You use 1 gram and prove. You have to prove, of course, with the results. Then yes, we can get. Yeah, one more. I mean, these are all the patents where I've used all the diabetic herbal mixtures have the same components. One or two components will change, they'll get the patent grant. So I'm a chemistry person. I've also used one more search, benzimidazoles. That was my PhD topic as well, benzimidazoles. So if I did, I got 4,211 results. Okay, 4,211 results only on the topic benzimidazoles. Right. So if you invent a molecule in the lab, you will not go back because it is already patented. Go to SciFinder or Reaxis. I hope you all know what the SciFinder is. Put the molecule. If SciFinder says no results, then yippee, we can go for a patent. If there are no results in SciFinder, the SciFinder will give you similar searches. If there are no exact searches, you can go for a patent. Come to us. We will charge less and patent. Thank you all for your attention. I hope you enjoyed the session. Next session will be little boring. That is why I wanted to make the first session little. I may have used some inappropriate slides, but understand that those slides are for your understanding, to make you understand better. So this is our Hyderabad BITS campus. You can visit us. So I'm luring you all to BITS campus by showing our campus. Any questions? I can take. Sorry? What? Word, W-O-R-D, word mark. Word that is nothing but a trademark as well. When you use some words like I'm loving it, it's a slogan. Those are all word marks. When you say, see, for Volkswagen, if you see, VW are the logo. But when you convert it into words, it is not Volkswagen, it is Volkswagen. Okay, Volkswagen, but they write it as Volkswagen. Those are word marks. No questions? If there are no questions, I feel either you have understood completely or you slept off my session. Okay, the other one. Yes, sir. Okay. Thank you all for your attention. I'm glad you liked it.
A very good morning to you all. On behalf of organizing committee Sri Padmavati Mahila Vishwavidyalaya, I welcome you all to the 5-day Advanced Entrepreneurship Skill Development Program in collaboration with National Institute of MSME, Government of India. And this program is being organized for limited number of faculty members, and we are very much thankful to our Vice Chancellor Madam for nominating us to understand about the patent rights, trademarks, etc., which are very much useful to all of us for our own, for protection of our own intellectual property, and also to teach our students and to encourage our students towards innovations and inventions. Thank you very much, Madam. May I now request with heartfelt gratitude and privilege our deeply respected and admired Vice Chancellor of our university, Professor Uma Madam, as the chief guest of this inaugural function of our program. I feel it honor to invite our beloved Registrar Madam and ever smiling Madam, Professor Rajni Madam, onto the dais. I take this opportunity to invite happily our Dean School of Sciences, Professor T. Sudha Madam, onto the dais. And now I request with high gratitude the program director of this program, Srimati Swapna, faculty member of Entrepreneurship Development, National Institute of MSME, Government of India, onto the dais, and we are very much thankful to you, Madam, for giving this opportunity to conduct in our university. Now I request the organizing secretary of this program, former registrar of Mahila University, Professor D. Mamata Madam, to come on to the dais. Now I request organizing secretary Madam to proceed the inaugural session.
Thank you, Vidya. I also request you to take the chair on the stage, please.
Second one, just double click.
Let's all raise for the invocation. Thank you all. Now it's time to know about the program and about MSME and about ni-msme. To this end, I request Mrs. V. Swapna to give a brief awareness about this one. But before that, I request Dr. Vahija to introduce the dignitary from ni-msme.
Thank you, ma'am. I take this great opportunity to introduce Srimati V. Swapna ma'am, who is having 18 years of rich experience in the performing corporate training and consultancy role. Madam delivering extensive training to both national and international participants on different topics such as entrepreneurship, innovation, intellectual property rights, skill development, and quality management at various sectors. Since 2015, Madam has been leading the Intellectual Property Facilitation Center for MSME, aiding numerous startups and SMEs in securing patents, trademarks, and other IPRs. Her contribution includes publishing 3 case studies on IP beneficiaries and authorizing 3 books on IPR. She has also developed standard operation procedures for training and course design, significantly contributing to ISO implementation and capacity building commissions accreditations. Her efforts in designing and organizing advanced management development programs and skill development programs have greatly beneficiaries for MSMEs. Madam actively involving in mentoring women inventors under the MSME innovation schemes and played a pivotal role in implementing major MSME schemes such as assistance to the training institution scheme, MSME innovative scheme, and entrepreneurship and skill development programs. She has also organized different skill development programs under PMKY 4.0, which created a greater impact of 6,000 beneficiaries. Madam is the recent recipient of National Teacher Award 2024 under the category of Entrepreneurship Development from our Honorable President of India. Thank you for this opportunity.
Thank you, ma'am, and good morning, all. Uh, Greetings from National Institute for Micro, Small, Medium Enterprises. Respected Professor V. Uma Garu, Vice Chancellor, Sri Padmavati Mahila Vishwavidyalayam, Professor T. Sudha, Dean, School of Sciences, and Professor N. Rajini Garu, Registrar, and also the organizing committee members, especially the Professor Mamata Madam, Vidyavati Madam, and other organizing committee members, and the speakers, Dr. Radhika from BITS Hyderabad campus, and also the professors and the faculty from various academic institutions. I warmly welcome on behalf of National Institute for Micro, Small, Medium Enterprises for this Advanced Entrepreneurship Skill Development Program on patent application, drafting and filing procedures in India. I'm very honored here to be in front of all to organize this particular program. And it is a first program under Advanced ESDB program. That is, actually this is a first program that we are conducting on patent, and this opportunity was given by the Padmavati Mahila Vishwavidyalayam. And we are organizing this particular program under ESDP scheme of Ministry of MSME. And the main objective of this particular program is to inculcate the skills, especially the advanced skills in the emerging areas. So ni-msme has been doing various programs in collaboration with various reputed institutions like NITs, IITs, and also various state universities. We are doing various programs on emerging fields like artificial intelligence, augmented reality, We are also doing on cyber security, circular economy, and we are also doing this year. We have proposed this advanced program on patent application drafting and filing. And thank you, first of all, VC ma'am and also the Mamta ma'am who came forward to organize this particular program in collaboration with ni-msme. And coming to ni-msme, ni-msme is a pioneer institute in the field of entrepreneurship development, and it's an organization under Ministry of MSME. And we have been doing various programs for the government officials, especially we are training various state and central government officials on various MSME aspects. And we are also implementing many of the schemes of Ministry of MSME. And recently, we are also been accredited with very good rating under capacity building unit under Niti Aayog, under especially this capacity building of all the government officials. Okay, and this particular program mainly helps the participants with the skills to draft the patent application, to know the procedures of patent filing process, and also to maintain the patent, and also to create the value out of the patent. Okay, so all the programs that we are conducting are mainly giving the inputs, especially to know about the importance of intellectual property rights. And this program will mainly focus on more on patents. So this is a very skilled area. This cannot be taught in 5 days, but we do our best to give many input, the important insights, okay, that can help you to draft the patent on your own. And also to know various laws and regulations that is there in the patent law, especially in India, and also while filing in the international system. Okay, and we have engaged the experts from different streams and also from the reputed institutions who will be giving the practical insights. Okay, and first session you all already had on the overview of IPR from Dr. Radhika from BEDS. So this 5-day program, you have both the lectures, theoretical, and also the practical exercises where you can work on groups and also know various databases and how to do the patent search and how to get the insights from the patent. Okay, so patent is a very technique. You get a lot of information from the patent. It's a techno-legal document, and especially for the academic institutions who are focusing on research, this patent information, learning about the patents and doing the patent search, you can get the insights which will give a right direction to your research, and it will also give the latest information which you can disseminate to the students. Okay, with all the trends and also the developments that is happening in your domain area. Okay, so I hope this 5-day training program will equip you with all the necessary skills, okay, that is required to do the patent search and also draft the patent application and also file the patent patent application on your own. And also we will be also helping you with networking and collaborating with various institutions, and also we'll give the information on the MSME schemes. There are a lot of support given by the government to promote intellectual property rights, and we have a scheme especially focusing on IPR, and we are also having an IP facilitation center at our campus where we are providing the services on patent and also on various other categories of IP registration filing, and also we are supporting for the IP commercialization also. So this is done for the MSMEs free of cost, and there is also a reimbursement scheme. So all this will be all this information will be given during my session. but I request all of you to have an active participation in this 5-day training program. Ask as many as questions to the speakers, and also involve in the sessions, and also I encourage discussions on various topics. Okay, so this, it is a two-way. Okay, maybe in some area you will be working and you may face certain challenges, and this will also, this is a forum where you can discuss and also get the inputs whatever that is required to you. Okay, and I wish you all success, and whatever the learning that you had in this 5-day program, please try to practice it. Okay, and all these presentations and information will be shared to you. Make better utilization of this particular training program, be serious, and this is an opportunity you got, only few people got the opportunity, and this certificate also has a higher value because this is given by the Ministry of MSME, and this will also will add on in your career. Okay, so please be serious and take this opportunity, and I wish you that this program will give the necessary inputs for you in this particular area, especially on patents. And I also thank Madam, VC Madam and Mamata Madam, and also this program register ma'am, for giving this opportunity. And I also thank our Director General Madam, because of her guidance only we could do such wonderful programs all over India. Okay, on various emerging topics. Okay, so I thank you once again, and I wish you all success, and once again I thank all the professors, especially Rajini Madam, Registrar Madam, and also Sudha Ma'am, the Dean, School of Sciences, who has given us the opportunity to organize this particular program at this particular campus. Thank you.
Thank you, Mrs. Swapna, for the great insightful inputs for the coming up program. Thank you very much. Um, it's time to hear a special message from our Honorable Vice Chancellor, Professor Uma Ma'am. But before that, I request Dr. Shanti to come and introduce our Honorable Man to all the participants and also invitees from outside.
Thank you, ma'am. Respected Yes, ma'am. Respected dignitaries on the dais, and respected faculty and my colleagues, a very good morning to one and all. Now it is my privilege to introduce Professor Vennam Uma Madam, our beloved Vice Chancellor of SPMVV. Professor Uma Madam is a professor of social work, trained in premier institutes both in India and abroad. And Professor Uma Ma'am works in the area of rural poverty and social development with specific reference to women and children. And Professor Uma Madam has a little over 4 decades of experience to her credit in teaching and research, training fieldworks, managing and coordinating fieldwork with a multidisciplinary team. And Professor Uma Madam is a qualitative researcher and has lead on the qualitative research for young lives in India. With these few words, I'd like to welcome Madam for today's occasion. We welcome you, ma'am. Thank you.
Thank you, Dr. Shanti, for the nice words. All the dignitaries on the dais, delegates, invitees, resource persons. Well, I'm really honored to be here this morning for a very special program. And I'm really happy that our university has been picked up by National Institute of MSME for the conduct of this special program under the Advanced Entrepreneurship Skill Development Program. And I congratulate Professor Mamata and her team for working with the Director General and very meticulously planning the next 5-day program. The job has been well done. Now it is up to the participants to make the best use of the program. I think, can I have hands raised by all the participants? have been identified. Okay. Initially, we were told that there will be only 20 participants for the program, but then based on the need of the hour and the specific need on our campus at present, we requested and they have agreed for another 10. So we are now having a very uh, relevant people sitting here, 30 of you who have been handpicked to be a participant of this 5-day workshop. So I'm really keen that you make use of this. And the faculty members who have been deputed are being given on duty leave to be here fully so that you make use of the input that you receive by experts in the field of patenting. Okay. Now coming to the workshop and the MSME, I think all of you are aware, I don't have to talk more about the National Institute of Micro, Small and Medium Enterprises. It is a national body and we have Srimati Swapna representing us today, but the Director General is going to come on the 14th. She'll also be there for a session and she'll be interacting with all of you to see how the 5-day workshop has been useful and what learning has been done. Now, just to make a brief mention, the Institute is providing services, a good number of services in the areas of capacity building, research, consultancy, skilling, education, and extension. So generally we think that MSME just provides some support to small scale industries, but they are doing much more than that. Out of these, I would like to pick up the incubation centers that are being supported by the MSME. And the incubation center at the MSME nucleates a cluster of new age ventures. The institute collects and disseminates information that helps make a successful entrepreneur who is well versed in the intricacies of business and can participate in business activities intelligently and diligently. At this juncture, I'm happy to inform that our TBI on the campus has already entered into an MOU with the MSME, and I'm hopeful that we can take the MOU forward and have good collaborative activities in future as well. Now coming to the workshop, we all know it is on patent application, drafting, filing procedures in India, and it is being conducted as part of the Advanced Entrepreneurship Skill Development Program of the MSME. So I am happy that this workshop is very timely and it has been rightly chosen by the MSME and also our organizer, Professor Mamata, particularly because of the context in which the SPMVV is today, where we have umpteen number of opportunities to file patents. And I have 3 reasons why I think this workshop is important. One, the advanced research that is taking place on the campus. Advanced research not only through the projects that are funded by the various funding agencies at the national and international level, but also from the PM Usha grant that we have received recently. So we have about 57 projects that we have given away to all the faculty. In addition, there are also projects given to the research scholars and the students. So we are looking forward to a number of patents coming out of this research that is happening on the campus. The second reason is the culture, the incubation and innovation culture that is there on the campus. We have been promoting this since 2018 with the establishment of the Technology Business Incubator followed by the WBIF. And I'm happy that the TBI is doing very well. Congratulate Dr. Surya Kumar. With about 43 startups that we have now, 43, and we are also receiving grant from Nidhi Prayas, and now we have moved on to Accelerator and Genesis. So, Startup India also. So we do have a number of people working and they all need guidance in terms of patenting. So another reason why I think it has been very timely. And the final one is it's one of the important criteria for all the rankings. They're asking us as to how many patents do you have. And I'm given to understand that the patenting process is not very simple in the Indian context. There is not much knowledge among the people also about the need and importance of patenting their work. And there is this huge process which goes through filing of the patent, publishing of the patent, and granting of the patent, which is a long, long process. And Dr. Suryakumar has been telling all our incubatees that once you have an idea, you have to first start filing your patent because you can protect yourself from the idea being grabbing, saying that others may have a similar idea, not exactly the same. So I'm really happy that this workshop is happening, very intensive. I've seen the schedule for the 5 days. Please don't feel tired. Listen carefully and make use of it so that you do the process accurately and in the way it has to be done. I think that is the very purpose of the 5-day workshop. Because I've asked Mamata to give me a brief note on what they are planning to do in the 5-day workshop. And she said that it will focus on a number of aspects. But what I find to be most important are understanding the legal framework within which the patenting process takes place in India. This is very important so that you don't get stuck anywhere. And patenting is not very easy. You need a lot of skills that are required, and the entire filing process itself needs support. Yeah, there are instances where people get frustrated because the application goes back and forth. And under the PM Usha, we also have one of the activities which is the establishment of the patenting center at the campus itself. So what I'm looking forward to is some of you will take feedback about all of you, the faculty in particular, who are participating in the workshop. And we will make use of your services to establish the patenting center on the campus. So once again, I request you all to be active and learn the entire process. And yet another area which Professor Mamta said will focus during the 5-day workshop is improving the patent quality. See, ultimately, it's not just the idea, but how you sell your idea is very important. So the way you write up, the way you give details. Recently, we have gone through a process with one of our students who is attending a program in Delhi. She is from pharmacy, I think. Pharmacy. And we were trying to help her to apply for a patent, also paying the required fees, which is quite huge, 25,000 from the TBI. But she was all worried about applying for a patent, not knowing that if she doesn't apply, her idea may get lost. So this is where many of the young people are who have an idea, thinking that they should not share everything. But unless you write up in detail and have a quality application, the chances of your patent getting accepted are very low. So I think you will all try to learn on this also, and how to protect your idea but also go for a patenting process. So the many issues that have been picked up in the 5-day schedule, and I'm hopeful that again you will all listen to them carefully and make use of it. So in summary, it will also help us for networking and collaborations because we have good resource persons coming from good institutes who have experience in the process, who have worked. So I'm sure they will be helping you also in future. Am I right? Yeah. Yeah. So they'll not only be the resource persons here, but they will be with us. They will give you the hand-holding support. So let us have more and more patents and more people coming forward, young people coming forward, not worrying about the patenting process. Okay. So finally, I think the process which we will be applying will ensure to be more effective, efficient, and legally sound after the training program is completed. And you will be providing support to many others, not only from SPMVV, but other institutions as well, through the patenting process. So, I am keen on knowing about the different funding sources for startups. There are various other topics, but today the SPMVV's process is
at a stage where we are looking for funding. So Swapna and the Director General and other resource persons, I'm hopeful will spend a little more time on this and help us to see how we can uh, commercialize our products and get more funding. Finally, the participants, I'm hopeful, will gain a comprehensive understanding of the entire process, patenting process, which is not very easy, quite complicated, particularly in the Indian context. And they will learn from the drafting to navigating the legal challenges and ensuring that their intellectual property is properly protected. I wish it to be a productive workshop with active participation of all of you who are attending this workshop. Thank you.
Thank you so much, ma'am. Very thoughtful points. And I hope everyone has making note of it, what madam has said. There's a very important, and when you, in the process of filing, when application moves back and forth, you really get frustrated. So it's that time you need to know what need to be done exactly, aptly, and proving your uniqueness of your innovation, be it a process or a design or a patent or a product. So, ma'am, thank you so much. Most valuable thing, ma'am. And I invite, it's time to hear from our registrar, ma'am. And before that, I invite Dr. Sai Lohita to introduce our madam. Madam, ma'am, let's take the privilege. Yeah.
Myself.
Yes. Okay.
So, Honorable Vice Chancellor and other distinguished guests on the dais, participants and my dear students, very good morning to you all. I'm Professor Rajani from the Department of Home Science. Right now I'm the registrar of the university. I'm very happy to share with you that most of my research revolves around entrepreneurship, innovation, women, and everything. So this, I'm very happy to be here because this program is very close to my heart. Because earlier to join the regular position, I have attended many entrepreneurship development programs in the national ni-msme. Earlier it was called as NICET, National Institute of Small Industries Extension Training. And when I was a student in MSc Home Science, my specialization is extension education. I visited the CET. At that time, it was called as the CET, Small Industries Extension Training. So from those onwards, I have some admiration towards that institution also. And I made few visits and I attended the training programs in the ni-msme also. And some of the persons also visited our university in 1990, during 94 and 96 as resource persons to conduct the entrepreneurship development programs. So always it's a very, I'm very happy to be part of this type of programs. And I thank the ni-msme also for choosing our university to conduct the first program, the 5-day workshop on patent application and filing procedures in India. Actually, we know, all of us know that when there is innovation, immediately we will think of the patent filing and the patent drafting and everything also. And all of us know that innovation is the backbone of progress and it drives the economy of the country. And also it shapes the future and it helps more lives also. And all of you know that entrepreneurship cannot grow in the vacuum. When there is innovation, automatically the entrepreneurs will come out also. So what you are all the young minds present here. What you have to do is try to think innovatively. First of all, observe the surroundings. You scan the environment. Then you will find out what are the things that are happening. Then what are the needs of the people? What are the issues to be addressed immediately? When you think differently, then definitely you will find the innovative ideas also. When there is innovation, it is very important to protect your innovation also, to protect your intellectual property right. So really, as our Vice Chancellor Madam said, I congratulate the Professor Mamata and also her team, Professor Vidya and other team members for organizing such a nice workshop which is going to address the different topics like understanding the patents and their role in innovation, and drafting, writing claims, abstracts and descriptions, patent prosecution procedures, practical demo for filing using the in-pass portal and everything. So this workshop definitely will be helpful for you. I invite all of you to take the advantage of this program, and experts are also here. Take their advice and learn how to apply for the patents and how to draw clear understanding of the ideas is also very important. Patent laws and everything. Definitely it will be helpful for you. Once again, I congratulate the team members and welcome you all. Thank you. Thank you very much for giving me this opportunity.
Thank you so much, ma'am. It's so delighted to know your, what is affinity with the MSME. Earlier, much earlier, I think 2 generations ago. Thank you so much, ma'am. It's very encouraging for us. Ma'am, I take this opportunity to invite our Dean, Professor T. Sudha, to give her few words of advice for all the participants.
Honorable Vice Chancellor of Sri Padmavati Mahila Viswavidyalayam and Chief Guest of today's function, Professor V. Uma Garu, Registrar Professor N. Rajini, Program Director, Faculty Member, School of Enterprise Management, V. Swapna, Organizing Secretary, Professor D. M. Mamata, Organizing Committee Members, Dr. J. Suryakumar Garu, Professor M. Vidyavati, Dr. D. Sujata, Vajiha Banu, Sai Lohita, dignitaries of the dais and participants. Very good morning to all of you. So I am glad to know that 5-day advanced entrepreneurship skill development program on patent application, drafting and filing procedures in India, organized by Department of Biosciences and Sericulture in collaboration with National Institute for Micro, Small and Medium Enterprises. Patents are very valuable assets that can provide intellectual competitive edge. So it has many advantages. One is exclusive rights, protection from competitors, increased profits, attracting investment, licensing, building reputation, and encouraging innovation, flexibility. So I am appreciating the organizers for organizing this 5-day workshop on patent application drafting and filing procedures. So I request all the participants to actively participate in this 5-day workshop and interact with the speakers to make use of the topics covered. These sessions will provide you insights in patent application, drafting and filing procedures. So I wish the organizers all the success. Thank you, Varenda.
Thank you so much, ma'am, for your wonderful thoughts on the theme patent application, drafting, filing procedures in India. And we have to catch up with the next session. We want to make the inaugural session very brief, for which madam has really consented, and she is not on time, maybe before time also. Madam is, she wanted to see that the time is best given for the participants and for the sessions. I sincerely thank you so much, ma'am. Actually, I went there to get some sheets, and meanwhile I just missing you. I'm sorry for that. Now it's time to honor our guests. No session is completed, it cannot be completed. So it's time to honor our guests. I request Oh, please bring in. I request our Honorable Vice Chancellor to honor the dignitary from ni-msme, Hyderabad. Ma'am, I request you, ma'am. Thank you, ma'am. Then I request the Honorable Vice Chancellor. No, I request Mrs. Swapna and the Registrar to honor our Vice Chancellor. Ma'am, please, it's a pleasure. Yes, ma'am. Yeah. Anyway, we'll be doing the. Yeah, anyway, it's honored to take from the Vice Chancellor. Ma'am, at least receive, madam, please. Kindly receive, ma'am. Ma'am, kindly receive, ma'am. Kindly. Ma'am, please. ఒక్కసారి విద్య ప్లీజ్ Thank you so much, ma'am. Now I invite Dr. Suryakumar sir to propose the vote of thanks. Yes, ma'am.
Good morning, everyone. Respected dignitaries on the dais and off the dais. On behalf of the organizing committee, I stand before you with a heart full of gratitude to express our deepest appreciation for your presence at the inaugural session of this prestigious national level program. The inaugural session has set the tone for what we anticipate will be a stimulating exchange of ideas, knowledge, and perspectives over the course of the program. First and foremost, I would like to express our deepest gratitude to our chief guest of our today's event, Professor Uma Madam, or Honorable Vice Chancellor, for accepting our invitation and being here, Madam. Your thought-provoking ideas has inspired us and left an indelible mark on all of us. I'm also running for the vote of thanks based on the schedule. Our gratitude also goes to Dr. Radhika of BITS Hyderabad campus, and then Mrs. Swapna Madam of ni-msme for your presence here, which added vibrancy and energy to the occasion. Your participation and engagement has made this event a truly memorable and enriching experience. Thank you, madams, for your gracing the event and being present here. I would like to thank our Registrar Professor Rajini Madam for a continuous support in making this event a grand success. We are very much honored, Madam, by your presence. I thank Professor Mamta Madam for presiding over the inaugural session, and your commitment and passion and enthusiasm has made this event more successful and being the driving force. I would like to thank Professor Sudha Madam for your presence here, Madam, and I'm grateful to all the resource persons for readily accepting our invitation and trying to be here to impart knowledge to all the participants. So without the presence of the participants and the resource persons, the event would not be successful. I would like to thank Director General NIMSE, Dr. Glory Swarupa Madam, for providing the financial support which made this event possible. I thank all the organizing committee members led by Professor Mamta Madam, and then all the members who worked behind the scenes, the IT team, and then the Saveri Hall team for making this event successful. And most important, wide round of applause and thanks and appreciation to all the participants who are attending here to make this event grand success. Thank you and have a great day.
Thank you so much, sir. Let's rise for the national anthem.
अधिनायक जय हे भारत भाग्य विधाता सिंधु गुजरात मराठा द्राविड विंध्य हिमाचल यमुना गंगा उच्चल जल वितरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय जय हे जय हे जय 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 हे
Jai Hind. All the participants kindly join for the snacks arranged outside. I, ma'am, one group photo. Quickly come to the front. Madam, మీరు ఇక్కడ రండి. Sticker పెట్టండి, బ్యానర్ పెట్టండి. Sticker, అమ్మ అరేంజ్ చేయండి అమ్మా.
ఫుడ్ స్పైస్ దీంట్లో ఏమొస్తుంది అక్కడ అదే వస్తుంది. ఫస్ట్ ఒక ఫోటో తీయండి. ఓకే.
request all the participants to come back within 10 minutes.
ఫుల్ సాంగ్ లాగండి దాన్ని సేమ్ చేయాలి. ఐదు నిమిషాలు ఉంది. మా జ్యోతిలో ఉండిపోలేదు. ఏది ఏది అది కింద ఆప్షన్ ఇది ఉంది లాస్ట్లో అది ఇది ఓన్లీ టీవీ.
All the participants are requested to assemble to the front seats, to the first two rows. All are requested to come to the front seats of both sides, two rows or 2 to 3 rows.
ఇక్కడ ఆపరేట్ చేసుకోవచ్చు మేడం ఆర్ కీబోర్డ్.
All the participants, please adjust yourself. Take your seats. Take your seats. All the participants, your attendance will be taken. So please say that you are there in every session. Now we are entering the second session. We are running late, so I request Madam also to kindly adjust. Yeah, 1 o'clock. Yeah, can catch up. So now for the second session, we have a speaker, Mrs. V. Swapna, head IP facility and also faculty at ni-msme. She is from Hyderabad ni-msme, and the madam is going to take a session on patent laws and regulations in India and also about Indian Patent Act 1970. So prepare yourself to go through the session. I take this opportunity to invite our resource person over to to take over the session. And is Dr. Shanti there? మళ్ళీ వైండింగ్ అప్ చేస్తారా? Okay, okay. Right. Ma'am, the floor is yours. Right.
Yeah, welcome back to the second session of Advanced CSDP program on patent application drafting and filing procedures in India. So, morning we had a session on overview of IPR where you had where you get to know about various IPRs. Okay, so you had a little bit about patents also. So now I will be telling about the patent laws and the acts in the patent law, and also what is the criteria for getting the patent, and also I will discuss some of the examples. Okay, and so morning you had on patents. Know what is what for what type of inventions patents will be granted, and what are the rights given under that. Okay, can any of you tell what is patent? Techno legal document, yeah. And what is the rights that you are going to get? Exclusive rights, right? Monopoly right, negative right, right? Territorial right, statutory right. Yeah, you're perfect. So you had, so the credit goes to Radhika actually. She has given you very good inputs, and that you could able to tell whatever I asked. And so coming to this intellectual property rights mainly deals with the human intellect, and we require resources, we require the human intellect, that is the brain, and the effort to execute your idea. Okay, so that comes as a property, that is nothing but intellectual property. Okay, so can you give an examples? Morning madam told about various intangible assets examples. So knowledge is one. Okay, so in your field also you come out with various innovative ideas. Okay, so that is nothing but an intellectual property. Okay, because when you are working on something and you got with some new idea which is not known to the public earlier. Okay, so that is nothing but intellectual property. Okay, so right helpful for protecting this intellectual property rights comes under intellectual property rights, and it is the rights given by the uh, given to protect the intellectual property for certain period. Okay, so there are various categories. One is patents, copyrights, industrial designs, we have geographical indications, trade secrets, and we also have plant variety protection. Okay, and today many sessions will be on the patents, but you need to know a little bit upon the copyrights also, where the brief is given already. Okay, and this intellectual property rights, majority are patents. Okay, in India we see lot of innovations coming out, and every startup are coming out with new business model, new products. Okay, so these are mainly protected by patents. Okay, so patent rights mainly help the inventor to manufacture it, to sell it, to give a license to others, or to what is to commercialize the product. Okay, to market the product. Okay, so the patent is mainly given for 20 years. Okay, it can be given for a new product, it can be given for the new process, or it can be given for the modification. Okay, for the existing product or for the existing process. Maybe some product is already known. Okay, and there is some problems associated with that particular product, and you have come out with some new idea which can overcome that particular problem. So you have found the solution for that. Okay, so that solution can go for a patent right. Okay, so this is we see a lot of modifications. Okay, but not that all innovations go for patent rights. Okay, there is certain criteria for getting the patent. Okay, so for getting the patent right, we have certain criteria, that is we have three criteria. One is novelty, inventive step, and also industrial application. Okay, and if any invention meet this criteria, this then only the invention is going to be patented. Okay, and before discussing detail about the patent, I will just touch upon the little bit about the IP regime in India. And the first IP law, especially the patent law, came from the British era, and where they have provided the protection for the products and the process, and the term is only for the limited, that is 14 years earlier. Okay, and later there was a modification in the patent law, and there was because of this monopoly right, many pharmaceutical companies, foreign companies, they own the right, and in Indian market they used to sell the pharmaceutical drugs at very high cost, and the government has taken a decision to protect only the process patents instead of product patents. That's how India used to produce the product with a new process, and that's how they were able to do it. Okay, but later there was an agreement called TRIPS agreement, trade related aspects of intellectual property rights, which says that every member country, okay, it is a agreement under administered by World Trade Organization, which says that Every member country has to have certain minimum standards to protect the intellectual property rights. Okay, that's how every member country has implemented their own rules and regulations to protect all kinds of intellectual property. Okay, so from 2005 onwards, India became TRIPS compliant and also started giving protection to various kinds of intellectual property. And that's how there was a protection given for the product patents also, in especially in the pharmaceutical and food products, okay, and agrochemicals. Earlier, there is only process patents for that, okay. So after 2005, India became TRIPS compliant and started giving the protection for product patents also. And earlier the term was for 14 years only. Okay, but after 2005, they have harmonized all the patent rules and regulations, and it is made uniform, and it is 20 years all over world now. Okay, so the patent is given for 20 years. Okay, so whenever you file the patent application, from the date of filing to it will be valid after the grant, it will be valid till 20 years from the date of filing. Okay, so recently there was a lot of amendments in the Patent Act, okay, and the first Indian Patent Act was 1970, and there was a key features under this act was to have the protection for the industry property, okay, that is especially the products and the process and any improvement technological innovations, and there is also provision for compulsory license, okay, and compulsory license, mainly I will also give the brief description how what is the criteria about the compulsory license. But the patent term was only 14 years in under 1970, but there was a lot of amendments and it became TRIPS compliant in 2005, and started giving protection for 20 years and introduced the product patents, okay. And recently there was an also amendment in 2019 under patent rules, where they have simplified the process, patent process, and then special provisions are made for the startups and MSMEs. And there is also timelines given for examining the patent applications, and also there is a timeline, there is a provision for getting the certificate for the inventors. Okay, I will show you the site where you can get all this information, but can I go to Google? So this is a site where you get all the information about the patents, okay, and this, there is a form and fees, okay. So before that you need to understand the structure of the patent, okay. Anyway, this will be dealt in the next session, but I'm just showing you the site where you can get the information, okay. This is a fee and also different forms that is applicable for the patent, okay. And there is also a public search option where you can get the information on the patents, okay. So as I said, patents is given for any new product or the process or any improvements. Okay. So whenever you want to see whether your patent is, whether your invention is patentable or not, there is certain criteria. Okay. First is novelty, means it should be new to the entire world. Okay. Whatever the idea that you have, whatever the improvement that you have made, okay, it should not be in the public domain. Okay. And the second criteria is it should have an inventive step, means there should be some technical advancement. Okay. So technical advancement means it should not be the obvious thing for the person having ordinary skill in that particular area. Maybe you are expert in some subject area, and some ordinary person may not feel that it is an obvious thing. Okay, when he sees that improvement, whenever he thinks about that idea. Okay, so then that comes under non-obviousness. And the third one is in industrial application. Okay, so whatever you make, whatever the product or the process that you invent, it should have some industrial application. Okay, suppose for example, when this smartphones, okay, earlier we used to give the inputs by just typing it. Okay, now you can now you have voice recorder, you can give the inputs. Okay, so that is something new, a technical advancement in that particular area. Okay, and there is some manual process, maybe in production of certain product there is a lot of steps involved and there is a manual thing happening. Okay, but you have invented a process which has automized all the manual process, and which you are able to get the output at a very low cost, and at the same time you can give a maximum you can get the highest means maximum production. Okay, so that is, so that process involves, there is lot of automation which has actually implemented all the process. Okay, with some technical inputs where you are able to get the output more effectively at a low cost. Okay, so that means by that you are able to produce a product at a low cost, then that can also be patentable. Okay, so if you have any invention, you have to see that uh, these three criteria is met or not. Okay, and apart from that, Indian Patent Act, this says that there are certain non-patentable inventions. Okay, one is frivolous inventions. Okay, I will show that. So there are certain inventions under Patent Act which is not patentable. Okay, one is frivolous inventions. Maybe the I may say that I have developed a device which is 100% efficient. Okay, you cannot claim that any invention, any device which you cannot be sure that it is 100% efficient. You cannot claim such things. Okay, and second thing is abstract ideas. Maybe the concept is there, but it is not an intangible. You have to show something which is um, tangible. Okay, that can only work. Okay, so whatever the idea you have to bring into a tangible form, then only you can get the patent right. Okay, and there are certain scientific principles which is already proven. Okay, anything that is having a method which is working on the scientific principles cannot go for patent right. Okay, and our ancestors, as in the opening session also they were mentioning about that, we have a lot of traditional knowledge given by the ancestors. Okay, so these already it is in the public domain. Okay, so this cannot be patentable because it is already in the public domain. Okay, so that cannot be given a patent right. Okay, and there is also certain inventions which is against the public morality, and also which is harmful for the environment, human life, and public life. Okay, So those, it will be harmful for the society. So such inventions can also not patentable under Patent Act. Okay. So these are clearly defined under section 3 of the Patent Act, which is not patentable. And also there is certain sections under subsections under this, especially which says about which is applicable for the pharmaceutical sector. Okay, like a simple modification of the known molecule or known structure. Okay, maybe if it is in the powder form and you have made it into other form like gel or crystalline form, so that cannot be protected, means that cannot be treated as an invention, and it cannot be patentable. Okay, and presentation of the information. So morning in the session they were saying that we have collected the information from the several sources and I am presenting for education purpose. Maybe that may be the new mode of presenting it, or you have adopted a model which you are able to give the information to the audience. Okay, but that cannot be patentable only because it comes under the literary works where there is a separate act which protects the information. Okay, and one more thing is any inventions relating to atomic energy or defense related applications cannot be patentable in India. Okay, and we also have known about the discoveries. Maybe you see there are new applications for already existing products. Okay, already existing things, materials that is known, but you have made a new use of that, cannot be patentable. Okay, and maybe the device is already known and you have made some new application. Instead of cutting, you have used that knife for a different purpose. Okay, so that is something new application for already existing one. Okay, that cannot be patentable. But suppose you have modified that product to adopt to that particular new application, then that can go for a patent right. Maybe in your field, maybe there are a lot of things which you have certain applications in different sectors. Maybe, but as it is, you are using for different applications, that cannot be patentable. But you have modified it, you have added certain more components to that device, or you have added certain things in that particular process and made it useful for a new application, then that can go for patent right. Okay, and these are certain things which are not patentable under section 3 of Indian Patent Act. And this already I mentioned about the atomic energy related. So these are certain things that due to national security concerns, atomic energy related inventions cannot be patentable. And any inventions, okay, relating to nuclear technology also, we can, it cannot be patented. And there is also international agreements where which says that nuclear related inventions, especially weapons and related technologies, are also cannot be patentable. And for the public safety and ethics also, these inventions are restricted, and it is only for the government use, not for the public, or it will not be granted for anybody who has made the inventions in this particular field. Okay, and as I said, patent, there is section 6. This particular session will be highlighting only the important sections of the Patent Act, which is actually required for you. So, under section 6 of the Patent Act, which says that who are eligible for filing the patent. Okay, it can be the individual, it can be means the inventor who actually came out with some invention, or it can be an assignee of the invention. Suppose you are the professor, you have worked on a particular research area, and you have come out with some product or something new invention where Padma University has funded for that particular project. So that university will be the assignee and you will be the inventor for that. Okay, and there is also legal representative, means Suppose the invention is made and that inventor has died, okay, his legal representative is an authorized person to file the patent application, okay. And it can be for the foreign applicants also, foreign applicants who want to file and protect their inventions in India. That's how we see a lot of foreign companies filing the patent applications in India because they have a huge market, okay. As patent is a territorial right, wherever you file the application, there only you will get the patent protection. That is the reason why many people, they try to protect their inventions in the countries where there is a scope for that particular product, okay. So where they feel that they can generate the revenue, where this maybe where their inventions will be useful, they will try to protect it in those countries, okay. So as an national, first I have to file the patent application in India and then have to file the patent application in other countries, okay. But if you feel that your invention is not applicable in India, and you feel that there is no certain no application or no scope for the market in India, then you have to take the permission from Indian Patent Office to file the application abroad, okay, in different countries, okay. For that you have to put a request to the patent office that you are filing in the foreign countries, okay. And similarly, the foreign applicants also, they file the first application in their home country and then they will file in the different countries, okay. So when the foreign companies, when they file in India, they will appoint a patent agent, okay, who is having an address for service in India, okay. So they should have an address for service in India and they have to hire an Indian patent agent to file the application. So as I told while filing the patent application, we require different forms. Okay, form 1 will be the application form. Okay, so where you need to give the details of the applicant. Suppose as an individual, you file the application and you need to mention what is your address, what is your contact details, what is the invention or title of that invention. Okay, and you also need to mention about the foreign applications also. Suppose you have filed the application in other countries, then you also need to mention, okay. If your foreign applicant is filing in India, they will also mention if they are giving. And also the inventors, maybe there are 2-3 inventors, their details also mentioned in the form 1, okay. Along with that, they need to pay the fee, that is 1600 rupees for the individual, for MSME, and also for the startup, and even for educational institutions. Now in the recent amendment, they have reduced the fee, and that is 1600 rupees. And they have to pay along with the application, okay. And there is also one more form, that is specification, form 2, which gives a detailed description about the invention, okay. So whenever you file the patent application form 1, you need to enclose form 2 where you will give the technical details of the invention, okay. So what this form 2 will be more technical, means you have to give all the details about the invention, which includes the prior art. Prior art means the background of the invention. Suppose you have made some product in certain area, and you have to see what are all the inventions that is already happened, which is already there in that particular field, and what are the patents that are filed, okay. So similar inventions done in that particular area also you may need to mention in the background, okay. So that is nothing but the prior art, okay. And then you will give the detailed description about the invention, okay. Suppose if it is a product, you give the product details, what are all those things. And if it is a device or it is a process, okay, device is there, means you have to give the diagrams of the device. If it is a process, then flow chart has to be given. And last part will be the claims, where you will mention about the technical aspect, what is actually the your invention is in a legal language, okay. Anyway, you will have a detailed section on the claims and also different sections of the patent structure, okay. And you will also need to mention Form 3. Form 3 about the statement of undertaking, that as I said, no, you whenever you're filing the foreign applications, you need to inform the patent office about the status of the foreign applications. Okay, so through Form 3. Okay, and there is also one more form called Declaration of Inventorship, that is Form 5, where you need to declare that inventor details, and also confirm that he is the inventor for that particular invention. So this is generally the applicant has to submit this form 5, where he confirms the, and under section 9 of Patent Act, which says about the provisional and complete specification, as I said, Form 2 will be given for mentioning the invention details. Okay, so there are two types of application. One is provisional application, and second is complete specification. So whenever you have an idea and you got the you are working on it. Okay, maybe you got some research fund and you started working on it, and you need certain time to actually make it prototype, but you have already have a idea. Okay, then you can just give the summary of that thing and file a provisional patent. Okay, patent application giving the summary about that. Okay, so why you need to do is, India follows first to file system. Whoever files first, they will be having the priority. Okay, that is why when many companies, what they do is, whenever they have certain new ideas, they first file the provisional application. Okay, so by filing the form 2, just they will give the summary of that, and then they will file the provisional application in order to protect their idea. Okay, then once they come out with some complete, whenever they complete it and they find that this is a invention with all the technical details, if they, then they can file the complete specification. Okay, complete specification actually it takes some certain time. Okay, and that is why first they file the provisional application and then go with the complete specification. But there is a time bound for this. Okay, whenever you file the provisional application, within 12 months you have to file the complete specification. Okay, so that is why you have to be very cautious. Okay, whenever you file the provisional application, within 12 months you have to file the complete specification. Okay, so it is not mandatory that first you have to file the provisional and then complete. Once you are done with the invention, that time also you can just file the directly the complete specification. Okay, so when you file the provisional application, it is only a temporary protection. It is not that your application will not be processed further. Okay, until you file the complete specification. Okay. And Section 10 of the Indian Patent Act talks about the contents of the complete specification. So one is title and field of invention, where it clearly mentions about the technical aspects. Okay, what about your what is your invention and what is the purpose of that, and what here, when you read this, okay, you will understand the area which the invention is. Okay, so whenever you are searching the information in Google, suppose whenever you have a certain suppose you are working in some research area and you want to see what are all the patents in that particular field. Okay, you can just choose a Google patent site and you just give the keywords and find out what are all the patents coming out in that results. Okay, and then you just go through the field of invention, then you will understand whether it is actually which is relevant for you or not. Okay, so you can just go through that, which gives a invention, what is the technology area, and also what is the purpose of that. Okay, and the next is background and the prior art, means whenever you do some publication, no, you write a review of the literature. Okay, similar thing is in patent terminology, it is called prior art. Okay, which includes the applications which are filed in that area prior to this invention, and also it is not only the patents. Okay, it also mentions about the publications also, non-patent literature also, what actually the research that is already happened in that particular area. Okay, so or in the background you have to mention till date what are all the developments that has happened in that particular area, and what is your invention talking about. Suppose there are some problem existing, and there are several solutions that is offered by different companies or different applicants. Okay, so you may be working on some in the same area, but you have come out with some solution, okay, which is better to that particular better than the solutions that is offered by others. So in the background, you mention about all the applications that are filed in the area or the publications which is talking about that, and you are mentioning that my invention is offering a solutions which is better than the solutions which is offered by others, and these are the advantages. Okay, so by reading this, the examiner will be able to sense that what is actually your invention is and how it is different from the existing applications. Okay, so drafting is a very skilled area, so you need to understand how to draft it. So that is why first you have to do your preliminary work. You have to go through all the applications in that particular area, and you have to see what actually they are claiming and what is actually their invention is, how they are writing it. Okay, so when you go through this, then you will understand and then start doing start drafting your application. Okay, so background and the prior art is very important, because you mention all the things that is already happened. Okay, this how actually helps the examiner to understand your invention. Okay, what is the objective of your invention. Okay, and then there is also section called detailed description, where you mention in detail about the invention, what are the different aspects in your invention, and you also give the diagrams where you explain the features of that particular device or the product, or if it is a process, the flow chart, everything you explain in detail in this detailed description. Okay, so you also try to mention, suppose you have worked out, maybe you are working on some composition way for treating certain diseases. Okay, so you also mention that these are the composition ingredients in that particular composition, and this is the ratio of the ingredient which I am using, and because of this, this is the efficacy that I am getting. Okay, or it is giving this particular result or treating this particular disease. Okay, you can also show some experiment results and all that you mention in the detailed description. Okay, at the end where you give the examples, okay, test results, okay, to show how your invention is effective, so that the examiner will take a call how it is different from the prior art, and also how it is useful, these things, okay, to decide the inventor step. Okay, and the next section will be on claims and drawings. Claims are nothing but, so whatever your invention, suppose I'm talking about this particular pen. Okay, my invention lies in ink dispensing mechanism. Okay, maybe I have the invention in that. Okay, so there are several patents talking about this. Okay, but my invention is something different, and I focus on ink dispensing mechanism, and my claims will talk about only that mechanism. Okay, where actually my invention is. In the description, I'll talk about my pen, and I refill everything, how it is assembled, and what is the benefit of that, and all that I will talk about in the detailed description. Okay, but my claims will talk about actually what is my mechanism which is involved in this invention. Okay, so that is one. And then the diagrams will be the where you give the diagram of the device. Suppose if it is a product, okay, device drawings you will give it. Okay, there is certain prescribed formats for each one. Okay, in the website you can see in that under administration forms and fees, and there is also patent manual which kindly I will also share with Mamata madam, where you can go through the patent manual. Okay, so you can understand what is the prescribed format for all these things. Okay, for drawings also there is a prescribed format which is mentioned by the patent office. You have to follow that. Okay. And under section 11 of Patent Act, which talks about the priority date of the claims. So, as I said, India follows first to file system, and the priority date means whenever the first filing, okay, first filing of the invention. Suppose as a applicant, I file in India and I also file in multiple countries. Okay, so my first filing, that is Indian filing, where I have filed first time, that will be the priority date. Okay, so there are different systems where you can file the application in other countries, okay, with the different routes. Okay, there is different Paris Convention. We have PCT also, International Filing System. Okay, where you file the applications in multiple countries. Okay, you are claiming the date of India where you have filed that particular date, and you're applying in different countries through different systems. Okay, so the first filing, that will be the priority date. Okay, and uh, there is also provisional filing impact. So if the provisional filing is done, then that date will be the priority date for that particular application. Okay, and if you are filing through the PCT directly, first you file the international application, okay, through WIPO. Okay, so that will be the priority date. Okay, instead of filing in the home country, just directly you filed PCT direct. Okay, so that will be the date for the priority. Okay, so whenever there is an examination or any validity, they always look for the priority date. Okay, suppose when they have filed it, okay, first. Okay, so to determine the novelty of that invention, okay, they will see what are all the literature in that particular area which is available for the public. Okay, so today I have filed the application. Then from till yesterday, what are all the applications that are filed in that particular area, they will go through. Okay, so that is why priority date is very important, especially when you are doing some patent search to determine the novelty, whether this is patentable or not. They will see through the dates, okay, till particular dates. And under section 11A of Indian Patent Act, they talk about the publication of the application. So we talked about provisional or complete specification. So once the filing is done, okay, once the provisional, if you file the provisional application, within 12 months you file the complete specification. Okay, after that only the process starts. Okay, it cannot just if you file the provisional application, it will not process further until you file the complete specification. Okay, so publication of the application, when it happens is after 18 months. Okay, so Indian Patent Office will publish that in the journal. Okay, so this is a date which is very important, because the day on which the public will come to know about your invention. Okay, they will publish the abstract. Okay, what is actually the your invention. You will also see the inventor details and applicant details who actually filed in this particular area, and public will come to know about that invention, that so and so person has filed the application in this area. Okay, so this is mandatory. The patent office will after 18 months they will publish it. Okay, but if you are in a hurry and you want to commercialize, if you want to market that particular product, or you want to talk with some investors and do have discussions, okay, and proceed for commercialization, then you publish it. You can put a request to the patent office to publish it early. Okay, so within 1 month after the request, they will publish it. Okay, so the publication is very important. In case of infringement also, whatever the damages they calculate based from the date of publication. Okay, that is why when the public come to know about this invention, so from the date of the publication. Okay, and 18 months is an automatic, and patent office will publish it. Otherwise, you can put a request for early publication. Okay, and there is also chances for opposition. In India, we have two types of opposition. Okay, one is pre-grant opposition, and after the grant also there is an opposition. Okay, why the patent office publish it to make it public, and if there is any opposition from the other stakeholders or anybody who actually knows that it is not a patentable invention, they can oppose it. Okay, but they may say that it is not a novel thing, it is already existing in these references, or it is lacking inventive step. Okay, so on any grounds they can oppose it. Okay, now they have introduced a fee also for the pre-grant opposition. Earlier there was no fee for the pre-grant opposition. Anybody can oppose it. Okay, just they need to give some explanation why it is, why, what are the basis for their opposition. But now they have introduced a form, and they have introduced a fee also for pre-grant opposition. Okay, which was lacking earlier. And pre-grant, uh, so there is a, after publication, it will be 6 months period for anybody to oppose. Okay, so anybody with some evidences, they can oppose it. Generally, these is a state where actually for the companies, the competitors will look into that. Okay, suppose I'm interested in other company because he is my competitor. I want to know what is the latest product developments that he is doing in that area. Okay, because I always want to know the competitors information, because have to make preparation to sustain in the market. Okay, have to compete with this product. Okay, so that's how many companies, they always try to have a watch on their competitors patents. Okay, so whenever the patent applications are published, they will see what is the thing, and whether they can oppose it or, okay, whether it is really worth of getting the patent, whether they will all see the grounds where they can oppose. Okay, and after the publication, if there is no opposition, it goes for the examination. Okay, so the patent application will not be examined automatically. Okay, then we have to put a request. Okay, so many applicants, they are unaware of all these things, and they just say that I have filed a patent application, but still my patent is not being granted. Okay, but actually you have to put a request for examination. Okay, that is also time bound. Okay, it is 48 months earlier, but now under new amendment rule it is 31 months. They have shortened the period, and you have to put a request to examine it. Okay, for that there is form prescribed, that is form 18. Okay, now under so whoever filed the patent application, you have to put the request for examination. Until that, the examiner will not go through your application. Okay, so it will not be processed. Okay, so this you have to keep it in mind. Okay, if you are not filing the request within that particular time, then what will happen? Your application will be abandoned. Okay, so this, many of the Indian patent applications are abandoned because of this, because there are many applicants are not knowing about the deadlines. Okay, so whenever you file an patent application, you have to be very cautious. You have to be time see the process at what stage that is. Okay, you have to have the knowledge. Okay, what at what stage what you have to put a request, and even for the office actions, if you get any query or the communication from the patent office, you have to communicate immediately. Okay, you have to respond, give the reply. Okay. So there is also for review and evaluation under section 12. There is a procedure described for the examination of the applicants. Once they will see um, they will see that whether the invention is patentable or not. Okay, whether it meets the patentability criteria, that is novel, inventive step, and industrial application. Okay, they will also go through, and whether it falls, they will also see that whether it falls in non-patentable invention. Okay, whether it is relating to atomic energy or defense related applications. Okay, they will go through all that, and then they will examine the patent applications in that particular area, and they will issue a first examination report. Okay, so uh, in the examination report, if they found any similar references which is close to your invention, okay, they will quote that reference and they will issue a report to the applicant saying that these are the things they raise certain objections. Okay, then you, as an applicant, you have to give a reply to that that objections. Okay, and within 6 months you have to give the reply, respond to that. Okay, otherwise the application will be abandoned. Okay, and there is a timeline extendable up to 3 months. Okay, but for that also you have to put a request. They will not simply extend it. Okay, and if they feel that after giving the explanation also, they will see whether whatever the explanation that you have given is convincing or not, and then they will decide to grant the patent or not. Okay, so as I said, in the examination they will go through all the references. Okay, that is prior art, maybe the patent applications and non-patentable non-patent literature also, like publications, any news, anything it can be, whatever that is available in public till that date. Okay, so they will go through all that application and they will examine it. Okay, so then they will decide the patentability. So once they decide whether it is patentable or not, or they, whatever the explanation that is given by the patent applicant, uh, they will not refuse, I mean, they will not simply reject that application. Okay, they will give the chance to the applicant to hear from the applicant. Okay, so they will also schedule the hearings. Okay, where we can attend and also explain about our invention. If you have any prototype, you can also show and explain. Okay, then you can convince the examiner how your invention is different from the cited references in the examination report. Okay, and this is so every time the patent application means when after the examination they will just not reject it. Okay, they will give a chance, okay, for the applicant. And after the hearing this thing, you have to submit the written submission. Okay, and if he is convinced, then it will be accepted, otherwise it will be rejected. So for that also, there are certain deadlines for the patent approval. Okay, the controller application, once it is accepted, they will put an order for the grant within 6 months after the FER issue. Okay, even there is a timeline set for the controller and examiner also. Whenever he receives the application, he has to examine within 3 months and also submit the application to the controller. Means FER report to the controller. Okay, once the FER explanation is received by the applicant, he has to respond to within 1 month. Okay, there are certain timelines also given to the officers, okay, in order to speed up the process. And there is 45 section which talks about the term of the patent. And as I said, from the start date of application till 20 years, the patent will be granted. And for the first 2 years, there will not be any fee. Okay. From the third year onwards, you have to pay the renewal fee. Okay. For means once a patent, suppose you have filed a patent and after 3 years it got the grant. Okay. For the first 2 years, there will not be any fee. From the third year onwards, you have to pay the fee. Okay. After the grant, you have to pay the fee. Okay. Till that, you need not pay. But the after the grant, the term is effective from the filing date. Okay. So for the first 2 years, no fee. From the third year onwards, you have to pay the renewal fee. And there is no extension after 20 years. Okay. And you also need to see what is the due date for filing the renewal also. Okay. If you forget and if you miss that date, then the application will be seized. And there is also, see, this is patent is granted uh, for mutual benefit. Okay, for first is for the inventor or the creator who actually made it. He has been given monopoly to manufacture it, to license it, to sell it, to use it. Okay, but at the same time, it also keeps the interest of the public, okay, and see that it is useful for the society after 20 years, okay. And government also has certain rights to use it, okay, in certain cases, okay. Can the Indian government can use a patented invention without the patentee concerned, okay, in case of some emergency. Suppose some invention is relating to certain disease which is actually prevailing in India, and there is lot of demand for that particular product and many people are suffering, then the Indian government can take a decision, okay, to use that invention, okay. So government has that, okay. And public welfare extension, so patented medicines and food items can be produced for public interest, okay, and non-commercial use. So for the sake of public, the government has a right to use for non-commercial and public purpose. And also patent relating to defense technologies can be used by the government without restriction. So government has a right to use it. So there is also certain rights defined to the patent holders, exclusive rights. So he has the right to use it, sell it, make it, and give a license. And also there is a right to prevent infringement. So anybody who has already means who has started manufacturing the same product without his consent, okay, somebody is infringing, then he has a right to take an action against that, okay. He has a right to give a license, okay, to any company to manufacture it. If he is not able to manufacture it, he can give a license to others, okay. Under Indian Patent Act, there is a thing is that Once a patent has been granted, it has to be worked. Okay, means he has to manufacture it or give license to any other company to do it. If you are not working for 3 years continuously, okay, the patent may be revoked. Okay, that is why when the patent is being granted, you have to work for that. Okay, it has to be, the product has to be what you have to manufacture it, or you have to give a license to others to use manufacture it. Okay, so in case of joint owners, okay, as a co-owners, okay, so what is the rights and obligations for the joint patent holders is equal ownership right, unless there is an agreement between the two owners, okay, it is actually equal rights will be given to both the co-owners. And consent also, in case of commercialization, if he is giving license to any other company to manufacture it, okay, so consent of both the owners has to be taken. And right to sue also against any infringement also, both the consent. And obligation to share the profit also same. And opposition before and after the grant, challenging patent validity under Indian patent. Pre-grant opposition, I have already briefed about that. And post-grant opposition, after the grant also, there is 1 year period for any stakeholders to oppose it. Okay, so here also there is with a proper evidence. Simply you cannot just oppose it. Okay, you have to have a proper evidence, legal means grounds for opposing this. Okay, so you may include the grounds may be prior art publication, prior use. So whenever you have certain invention, you should first file the patent application and then use it, or you manufacture it. Sorry, you have to disclose to others. Okay, suppose you are exhibiting in the exhibiting to public. Okay, maybe displaying that product in some exhibitions. Okay, and there is a clause in Indian Patent Act that within 6 months after exhibiting that particular product, okay, in the exhibition they have to file the patent application. Otherwise, they will lose the eligibility of getting the patent. Okay, and you should not do any commercial activity before filing the patent application. Okay, that is also there. Okay, grounds for opposition. And there is also a concept called compulsory license. See, as I told, the patent owner uh, has to manufacture it or give a license to others. Okay. So there is also one grounds where any company who is interested to manufacture the patented product. Okay. So there is a chance of getting the compulsory licensing. So suppose any company is not manufacturing it, okay, and it is also not giving the license to any other company to manufacture it, okay, then they can apply for the compulsory license. So, and for that there is a grounds for, I think, there is a grounds for compulsory license. One is whatever the patented invention should be worked in India and should be available in sufficient quantity in India, and it should be sold at an affordable price. Okay, so if these three important criteria, and this patent has been granted for more than 3 years, okay, then they can apply. Any company who is interested can apply on this particular grounds. Okay, and there was a recent case study, like case first compulsory licenses was issued to Novartis. Okay, there is a patent granted to Bayer for an anti-cancer drug, and Bayer has does not have any manufacturing facility in India, and they started selling that drug at a very high price, around 2 lakh rupees in Indian market. And you know, India, we have a lot of patients suffering from cancer, okay, and that is not available in the sufficient quantity also. So Novartis made a survey and they have come out with a report saying that and submitted that to the patent office and requested, actually first Novartis has approached Bayer for license, but they have rejected it. They have not given the license, and then they have with some evidences they have gone to the patent office and they have applied for the compulsory license, and this was the first compulsory license issued to Novartis, and Novartis started manufacturing that particular drug and start selling that at a very low cost, that is 8,000 rupees. Okay, so that is also there. So anybody, any patent owner, if he is not working on that invention and not giving license, then it is also provision for compulsory license where any company can apply on that grounds. Okay, and for that the controller has a power to issue the compulsory license and also fix certain royalty. Okay, and you also can revoke that compulsory license if the applicant, patent applicant, works for that and started set up some manufacturing unit in the country to sell that particular drug or product invention at an affordable cost. If he is selling, then it will be revoked. And section 104 will talks about the infringement suits. Anyway, this I will not be talking about. Anyway, we have a detailed session on patent enforcement and also IP commercialization, patent commercialization. So, just I want to brief about the latest trends in the patent laws. And you can see in the last 1 year, we have seen significant increase in the patent filings, especially in the AI and software patents. And there is also a lot of patents being filed in the green technologies, okay, and renewable energy. And most of the patent applications are filed by the academic institutions. When you see this, after the amendment, the fee has been reduced for the academic institution, and they have categorized same like MSME and startups. And you can see a lot of applications have been filed by the academic institutions, and there is also support, government support is being given. Ministry of Education giving a lot of schemes where they are supporting the educational institute to file the patent application. So, as per the recent amendment, there is a reduction in the official fee, and there is also a national IP policy brought out by the Ministry of Industry and Commerce, where there is a lot of awareness spread among the students, educational institutes, and also for MSMEs and startups. A lot of programs have been initiated, a lot of incentives have been given for the startups, and there is a fast track mechanism examination for the startups also to speed up their applications, and incentives are being given for the startups. There is also tax exemptions for 3 years. Any startup is having an IP registration, they are giving 3 years tax exemptions also. So there are certain benefits under startup action plan supporting these startups. Um, and these are certain things under Indian Patent Act which is important to you. There is a lot of history associated and lot of agreements, international agreements, and there will be in detail talk on the PCT also, international filing system. This only pertains to India, where actually the process is involved. And afternoon I will show you the demo where you can see how the application is being filed, what are the different sections, and how to means what are the different forms that is required, and what is the fee that is applicable and all that. Okay, if you have any questions, I will hope you understood what I said. And it is a very lengthy topic, within 1 hour or whatever that is required to you, I have just briefed it, but you have to go through each one of them and understand. So immediately after the session, maybe today itself, you will go through the forms and then you will understand actually. Then you can ask the next speaker on in whatever the doubts you have. Otherwise, you can write to me also. Okay. Thank you.
Thank you, Swapna ma'am, for giving a deep insight on historical background and evaluation of Indian Patent Act, various criteria to be met while filing the patent, along with various forms, content to be included, etc. With this, we end up this session. I request all the participants to join for lunch in the dining hall, and sharp will meet again at 2:30 here for the next session. Thank you.
Yes, the menu will be very interesting all the 5 days. So bring in your appetite also when you're coming to the sessions, okay? Yeah, all the 5 days. Wonderful. And now, yeah, this session will be very challenging in the sense you should fight yourself to keep yourself alert and listening and understanding and making it vibrant and interactive also. Otherwise, we will come to you and make you interact. We'll wake you up and make you interact. Okay? So, so the deal is yours. Either you interact, otherwise we will come to you, wake you up, and interact what has been done. Okay? Yeah. And now, I mean, we are going. Entering the third session. Dr. Radhika Reddy, she's going to, go ahead with the third session. Do you have some sessions? Third session. Yeah, the third topic being patent and its significance and patent structure. Okay, so quite interesting. And after which, as a continuation, um, Swapna ma'am will going to handle it on a hand-holding session. Okay, so be alert, give all your best effort to keep yourself alert, and make the session interesting for the resource person also. So, please. Well, let's welcome Gattiga. Yes. Parallelly, a small request, some detail has to reach the ministry. So the 20 core team are requested to give in your details, and Dr. Sweta is helping me in that. So try to put the details here whenever she calls you, right? And the details has to go correctly because once given, it cannot be rectified. So please see that your Aadhaar and your personal details, your father's name and other details should be given very carefully, along with your name too. Okay? Thank you all. Please go ahead.
Good afternoon, everyone. Uh, I promise that this will be a little boring, not as interesting as the morning session. So, as ma'am said, you have to give all your efforts to stay asleep, without sleeping for the session. Um, so, this session will be significance and structure of the patents. We will learn why exactly we are going for the patents, why do we need to go for the patents, and then the structure of patents. So brief structure was given by Swapna madam in the morning. So I will go into the detail. What is the structure? What exactly a patent consists of? The backbone and the details. First, we'll see what is the significance, why we are going for patents, and exactly why we need to protect our inventions. So this was the patent given for a safety pin in the year 1849 by USPTO. There is a small story behind this. So why am I putting this slide? You will get to know later. So this person is so don't assume that I'm a storyteller.
I have a kid. I don't even tell stories to him. I'm telling you the stories. So this person, Walter Hunt, he had a debt of $50 in 1849. So you can imagine $50 is a big amount. Of course, today also it is a big amount. So he owed a person $50. So one day he sat in a corner and was winding a wire, iron wire, and that wire suddenly he made into a pin kind of structure. He thought he could stack clothes using that pin. He named it as dress pin. Dress pin, and he wrote a patent. You can see the patent if it is visible. The patent is named as dress pin, not safety pin, and also not this picture. That was little different. Later on, after a few modifications, we got this safety pin as the final product. So he named it as dress pin, and he got a grant for that dress pin. So he sold that grant to the same person whom he owed $50. He sold his patent for $500. So he cleared his debt and got a labam for $450. So see, in those days, in 1849, he commercialized his patents. So that is the significance behind why patent. Because see, if he hadn't patented that in 1849 and he sold, maybe he might have sold. So someone will copy. So, for example, if you are selling one safety pin for 1 rupee today, someone will copy and sell 50 pies tomorrow. But if you have a patent, no one will copy. No one is allowed to copy. If they are copying, they have to pay you royalty or they have to pay you some licensing fee and get the patent licensed. So the realization of commercialization and patenting was there in 1849. So today many institutes, organizations are going for patenting, but you have to take a step forward and go for commercialization as well. License your patents and then prosper. So this example is for that. Do we know him? So why am I putting his picture here? See, my slides mostly has inappropriate slides, but of course somewhere related. So what is he doing? Yeah. So what if we try to do that step? We will fall on our faces, break our nose. But how is he doing that? Do you have any idea how is he doing that step? Yes, because of his shoes. The shoes were made differently so that when he stuck the shoes to the ground, he can bend at an upward angle, defying the gravity. And when he presses the ankle or the sole of his shoes to the ground, he will come back to his original positions. That means the shoes are allowing him to make that angle, that pose, dance pose. So Michael Jackson owns a patent for those shoes. Okay, so he owns a patent. And now tell me, after these two patents, is Walter Hunt an inventor? The one who invented safety pin. Is he an inventor working in the lab? No. Michael Jackson didn't even finish his school. Is he an inventor? Of course, the cobbler might have made the shoes, but the idea was Jackson's, right? So neither Jackson nor Walt Hunter was not inventors. They did not work in the lab, but still they own patents because of their miraculous inventions. So what am I insinuating here is, see, you don't have to be a big scientist in a lab to file a patent. You can be a small inventor to file a patent. It can be a small invention like safety pin to get a grant. You know, toothpick also had a patent. It was a patented invention in the year 1891. Of course, our Indian Patent Act wasn't there. This is a US patent. After 1891, 20 years it will be dissolved. Don't worry to use a toothpick. It is now patent free. I mean, the grant is still there, but still it is dissolved, open to public. Apple has so many patents. Each patent is derived from an invention. Okay, from an invention. So say this. I hope everybody knows the slide button. Samsung copied it from Apple a bit later, but Apple got this idea from this. So I think those slides are not there in these days, but it used to be there in our ancestral homes. Those slides. Our first Indian patent was in the year 1856. Before independence, before our Patent Act came into existence, it was by George Alfred deepening. So this is on a punka pulling machine. This is not officially an Indian patent, but an Indian patent nonetheless. It was before the act came into existence. So he wrote it in a paper. So there is a story again behind this. So he was so kind. This person was so kind. So previously in olden days, there were no fans, electrical fans or no ACs and all. So when a court was going on or in a room of all the ministers, a punka was, decorated on the ceiling, and that punka was so huge. I mean, the entire hall should be circulated with air. So the punka was attached to a thread outside the court, outside the hall, and several people used to pull the punka so that the punka used to travel from this end to the other end. So the labor required was huge, and the people who were pulling the punka also were tiresome. After few times, they were tiresome. So this person was very kind, and he started thinking and invented this punka pulling machine. So this punka pulling machine was invented, and then it was easy for the labor to handle the air circulation inside the hall. So he wrote he wrote a patent for that. Since the invention was done in India, I said territorial jurisdiction and all. Since the invention is done in India, but USPTO was well established in those years. Our Indian Patent Act wasn't established. So he wrote it in India and filed a patent. So our first Indian patent is on punka pulling machine. As I said, we will talk about basmati rice. So this basmati rice, who owns it? Where is basmati rice usually grown? Of course, basmati rice belongs to us. See, the scientific name of basmati is nothing but Basmati. Basmati means a fragrant or aromatic. So it is derived from Basmati word. So Indians own Basmati rice. So what happened is Americans started growing Basmati rice, and they filed a patent for that. You can see the US patent which was filed for Basmati rice. Later on, this was filed by Rice Tech company from USA. Later on, we as Indians fought for that because Basmati was owned by us. Later on, they copied Basmati and they started growing the same thing but under different names, Kasmati and Texmati. Texmati from Texas. So they changed the name, and they are telling Kasmati and Texmati, it belongs to us. But still, Basmati belongs to us. Still, they copied, and when they copied Basmati, we opposed. Then they changed the name to Texmati and Kasmati, and they're still growing. So they copied and stole this from us. And the next one is turmeric. They tried to steal turmeric from us. There is a story behind this again. So, two students from University of Mississippi, what they did is they filed a patent. What patent is that? Filed a patent as wound healing properties of turmeric. Wound healing properties of turmeric. So, I have a question before this. If there is a small cut on your skin, what will you do? Even he knows that. If there is a small cut on the skin, he will go to my purple dabba, open that and put haldi, turmeric on that. Small kid in India knows why he doesn't know, but how he knows. So if there is a small cut on our skin, we'll put turmeric. They don't know the action it does, but still, why do we do it? Yes, it has. Yes, antiseptic properties. Antiseptic properties, wound healing capacity. As if we don't know. So these guys, two guys from University of Mississippi, filed a patent on wound healing properties of turmeric, and USPTO granted them the patent. And you know what? Those two students from Mississippi were Indians. See? As if they did a new invention, they filed a patent and got the grant. So CSIR opposed the patent and fought for this turmeric is a traditional knowledge. How can you patent it? Then the patent was withdrawn. I don't know about those two students, but patent was withdrawn. Now turmeric is ours, unlike basmati. Neem. We all know why neem is used. It is an antifungal agent. Okay. Even European Patent Office. A patent was filed from some university proving that neem as an antifungal agent. So they got the grant. Again, India has to fight and then get the patent withdrawn. So all these were piracy, bio-piracy cases. So because they were trying to steal our information, which is our traditional knowledge. That means from since long ancestors, thousands of years ago, we are using these things. We know the use of these things, so they can't steal this information from us. Then came into existence, after this biopiracy has happened, then came into existence the TKDL, that is Traditional Knowledge Digital Library. So until recently, this TKDL wasn't opening to anybody. It was open to only patent office and higher authorities. Common man couldn't you open this. Even we patent attorneys weren't able to open this TKDL until recently. But last year, I think since last year, they gave access to each and every person. You also can go to TKDL and open any document. So there are thousands and millions of documents of traditional knowledge in TKDL. You go, you will be fascinated by the documents we have, by the inventions we have. See, sometimes what happens when examination is happening, that means the controller is examining your application, patent application. They take, for example, you have any herbal compositions. They take documents from TKDL and throw it at you as opposing documents. That means your invention is similar to this herbal mixture in TKDL. This can be a prior art for your patent. So before you file a patent, of course, we cannot check the entire TKDL library, but ensure that that composition is not there in the prior art. So in the TKDL, you can get everything, the Unani, Siddha, Ayurvedic, everything you can get. Coming to the 3P rule, I wanted to know, all the academicians to know about this 3P rule. Publish, perish, patent, publish, and prosper. There is an article as well. So what do you mean by the first 3Ps? When you publish an article in the journal. Say for example, you from this university we got a wonderful medical device. Say a medical device, and they have published this in the article. I mean journal, any journal. So what the other people do? They will take, because you have published in the article, it is not that you are not opposing anybody to use that. So someone will else copy your medical device, do a little modification, and or not even a modification, then they can as such commercialize it and sell it. Isn't it? When you are developing a medical device, I can copy the medical device, I can open a big startup and then sell the medical device. You have no right to come and ask me that this is my medical device, because it is open to public. You have published an article, isn't it? I can say I'm using it before you published your article, right? That is why do not publish your articles before patenting. Say, second 3Ps, patent, publish, prosper. Say the same medical device, you go for patenting, right? So today I filed a patent. Tomorrow I can publish the article. So if someone is trying to copy your medical device, okay, that is good for you only, because when you see that product in the market, you will get to know who is selling them. So you go to them, you can file a case, sue them. They will pay you royalty in lakhs and crores of rupees. So always go for patenting and then publish. See, today you filed your patent, tomorrow you can publish your article. That means as soon as you communicate it to the attorney, you can immediately approach the journals, because when you approach a journal, they won't immediately publish your article. They may take some time, isn't it? So go ahead. First, always file a patent, and then if you feel your invention is worth for commercialization. Don't feel your invention is not worth for commercialization, because if a safety pin can go for commercialization, then definitely your invention can go for commercialization. Look through proper channels. Look where other industries are working with your, I mean, see for example, I made a medical device, so I will look through the companies wherein they are investing in medical devices. So look through them and work through that channel and get your invention commercialized. Then you will prosper. Walt Hunter prospered by $450. So why can't we? Even we can prosper by commercializing our invention. So remember the 3P rules always. Always patent and then go for publishing. Yes. Ma'am, there is a recent, not even recent, there is a section for that. So when you present any information, when you go for publication, you can file patent within 12 months. Within 12 months. But if you cross that 12 months, then you don't have any, right. So until recently, if an article is there, then you will not be able to publish. But last year, March, an amendment came wherein even though there is an article in the journal, say you have published an article on January 1st, 2025, then you will have the right to patent until January 1st, 2026. You can patent until January 1st, 2026, but not after that. That means you will lose the rights because it is open in the public domain. For that, you have to file an extra form. That's it. So why patent? Why do we need to go for patenting? So first thing is we have to, when we file a patent, we will protect our invention, as I said. If we protect, then definitely we can publish and then prosper. Then if you see, we have a problem, say our invention, we can show the solution through our invention. So patent exactly gives that. If we have a problem, we will give the solution to the problem through our patent. And then when the problem and the solution aligns, I mean, if your solution is perfect, then yes, you have given a solution to a problem, and then go for licensing or commercialization. That is why we have to patent it, so that we can protect our invention. Why are patents necessary? See, today, whatever we do is for money. I hope you all agree with that, right? If we do patents, if we do research, if we work, we are not doing as a social something, not for an NGO, right? We are working for money. So why do we do patents? Investing so much amount. Why do we do that? For money, isn't it? So when you file a patent, don't sit calm and file a patent. Go and commercialize it and prosper from the patent. What is the type of protection the patents offer? So first thing is it will offer protection from the potential infringers. See, there is no system like it will stop someone to copy your invention. No one can stop someone to copy your invention. But see, we want always someone to copy the invention, because if they copy, then only we will earn, isn't it? But you should be clever enough to identify the infringer. Okay, clever enough to identify the infringer, as well as clever enough to take him to the court. So take him to the court and then prosper from that. Like how you have seen the case in the morning, camphor as well as Patanjali, camphor cone. So that was the trademark case. Similar thing will happen in the with the patents also. So what rights do patent owners have? What rights do we have? We have all the rights for licensing and commercialization. And next is we can stop anyone. Of course, we can't stop government because there are special cases, sections for that also. For emergency medicines, as ma'am told in the morning. So we can stop anyone from buying, selling, making, using, importing our invention or our patent. So these are the exclusive rights given to us, right? As patent owners or as patentees, we have these rights exclusively. So that was the significance of patents. So significance, why? What is the significance in patenting? First thing is you will get the protection for your invention so that no one will copy. Then you will prosper. Okay, you will prosper. With an article, you cannot go anywhere. Just publish the article, sit on it. That's it. But when you have a patent grant, you can go for commercialization and prosper from it. So that is the major significance or the major difference between a patent and a published article. Structure of patents. So what exactly? See, anyone can write a patent, right? As in, see, you don't have to wait for the attorney to write or file a patent for you. Any natural person can draft and file a patent. Okay, but if you want a grant, definitely the attorney will, should help you, because you need the legal side of that. You need to understand the sections, because without the sections you will not, of course you will be able to file and draft, but you will not be able to prosecute. For that you need a patent attorney. But drafting and filing, maybe you can do and try. See, few of the universities are trying for drafting and filing, but they are stopping after publishing because they can't answer all the questions in the FER. It is not as simple as a review comments, what you get in a article. See, in the journal also, when you publish an article or you send an article to the journal, you will get review, isn't it? You will get the review and you will have to answer the reviewers' comments, isn't it? So it is not as simple. See, since it is your invention, you can answer the reviewer comments. But here, when it comes for the examination, you will not be able to answer all the objections. Maybe the technical side, yes, but they will put sections. Without sections, you will not, your invention will not go for patenting. So definitely you will need an attorney. So when the attorney comes and sees your invention, the attorney says the draft is not legible enough for us to answer the questions. So I suggest from the beginning only you take an attorney, because from the beginning your invention will be filed properly. Because if you file, you will get more, what should I say, more comments. So they will throw more sections on you. So better get a draft officially from a patent attorney. This is a structure. What are the contents of a specification involved? So there are two specifications, as ma'am told in the morning session. What are those two specifications? Provisional specification and complete specification. Provisional specification is if you have some invention still left to do, then you file for provisional specification. But if your invention is complete, then you can, you don't have anything to do else with that invention, you can go and file complete specification. So I am telling for complete specification only, because provisional is nothing but a simple, without some claims and all. I will tell you the difference also. So these are the basic contents you will have in any specification, but provisional you will not have claims and all. So specification basically contains the title, preamble, technical field, background, objectives, brief description of the drawings, detailed description of the invention, claims, abstract, and drawings. So any draft, whether it belongs to sciences, whether it belongs to engineering sciences, any draft will have all these side headings. So few may not have drawings. So yes, we can omit. Without drawings also some inventions are there, wherein brief description of the drawings we can omit. But rest of all the things are there. So if we don't have drawings, two headings will be gone. But other than those two headings, other side headings are mandatory. If you do not include any side heading, if you don't have drawings, fine. But if you miss any side heading, then the examiner will give the examination report that this side heading is missing. That will be an objection as well. So again, you have to amend the application and then apply, you have to amend your application. So these side headings are very, very, very important. You should not miss. So once when during my early days, something is also missing here. Summary of the invention has to be added. Before brief description of the drawings, there is summary of the invention. So once what I did is I misinterpret. I mean, I think after brief description of the drawings, I introduced summary. So I wrote summary after that. Immediately there was an objection. So summary of the invention should be there, not here. That was an objection as well. And one time what happened, my drawings, so there are specifications like the page on the top and left should be 4 centimeters apart, right and bottom should be 3 centimeters apart. So I didn't follow. Usually our A4 size has 2.54 centimeters on all 4 sides. I uploaded the document with 2.54 centimeters on all 4 sides. There is an objection. Please upload the document again with the specifications mentioned in the Patent Act. So very meticulously you have to draft. So you will not be able to read all the sections. You will not be able to, nothing is impossible, but you can. But simply I'm saying because it is better if a person who knows all the sections drafts the specification. So such meticulous observations will be there. Such small observations also will be made. And very recently, I have written a patent for Kakti University, and instead of solubility, I wrote stability. He observed that also, and then he pointed out this line instead of this, you wrote this. Please correct. That was an objection. Again, I have to amend the application and correct the claims with this. This change. So we will see each side heading exactly. Title, we cannot keep big titles. So first page of the specification, or we call it as Form 2. Form 2 can be either a provisional specification or a complete specification. So first page is a title page. Okay. So we have to write the title. The title should not be so pompous. It should have less than 15 words. A is also a word counted. The is also a word count. So you cannot put a big title. The title should be restricted to 15 words, including a, the, and everything. And your title should not contain novel, these words, novel, and it should not contain any names of your university or yourself. It should not contain all these words or any pompous words like increase, decrease, like this. Try to avoid all these words. More efficient, better than anything, like these words. So you will not describe your invention, in a very great manner or more efficient way in the title. Simply describe your invention in the title. And when you're writing claims, title name should come in the claims. First claim at least, right? So that means whatever your major part of the invention, after reading the title, we should be able to know what is your invention. So your title should be describing the invention, not the other things. So an example is given. The invention is about a coffee dispensing machine. See, there are two titles here. Apparatus and method for dispensing coffee. Simple title. Or coffee dispensing machine and method of dispensing coffee. That's it. Simple title. Then the preamble. After the title will come the name of the applicant. If it is you, you can write your name including the address. After the name and address of the applicant will come the preamble. Preamble means provisional specification as well as complete specification. We have to write a preamble. Preamble means the following specification describes the invention. That is for provisional because we are not going into detail. But for complete specification, we have to mention it. The complete specification completely describes the invention and the best method to perform the invention. So the preamble is mandatory. If you don't write the preamble, again it will be an objection. That will be just a line or two. That's it. That is your first page of complete specification or provisional. For both of them, it is same. It is same, just that you will write complete or provisional. Next, from the second page, your actual draft starts. The second page consists of technical field. So the technical field will be the first side heading in the second page. So what is technical field? For example, I'm writing about a drug molecule. I have invented a drug molecule in the lab. So the technical field will be pharmacy. I will write the invention. The technical invention described here belongs to the field of pharmacy and its method of preparation. That's it. One line or two lines. You will not write stories in the technical field. You will write. So for the coffee machine, which we wrote a title, same thing. See the embodiments here in generally related to dispensing machines and more particularly to an apparatus and method for dispensing coffee. That's it. That is the technical invention, technical field, to which field the invention belongs to. That's it. After technical field comes the background. So here the background is as similar to the background of your article. See, in your article, what do you do? See, you might have experience in writing an article, right? So in the article, what do? You will write about the literature. See, in that literature, this work is there, this work is there, this work is there. All these works, my work is the best method because my work has these many advantages over these works. That's what you write in your background for the article. Same thing you will be writing it here. But in those articles, we write about our work as well. But here you will not describe your work and you will not berate your work. Do not write anywhere about the disadvantages of your work. Though they are disadvantages, they have disadvantages, do not write it in the specification. That means you yourself are telling that your invention is not good enough for the patent, right? So background, what do you write about the background? Whatever is there in the prior art for your invention, write it in the background. If you have, say, one prior art which is better than your invention, do not mention it. Mention the background. Of course, eventually the examiner will identify, but you do not go and give the green check to him that this is better than my invention. Never. Okay. So in the background, you will always write the inventions which are already invented. Though patents or any articles you can write. Mention them, give the DOI, no problem. Write everything and say in one or two lines, this is what you are doing. In those 1 and 2 lines only, you will be explaining your invention, how it is better. Right? That is the background. It is as similar to our articles. Objectives. So these are the objectives. See, few articles, they ask you to write the objectives. For example, I have designed a course. Okay, I have designed a course. What do we write? First, course objectives, course outcomes. So forget about the outcomes. So first, course objectives. Right? So say we have that coffee dispensing machine. What do we write the objective as? Can anyone tell me the objective for a coffee dispensing machine? Yes. An objective of the present invention is to is to what are we doing? We are making an apparatus to dispense the coffee. So an object of the present invention is to provide an invention related to coffee dispensing machine. Can we write another object? Another objective of this invention is to understand the dispensing mechanism of the coffee. Can we write another object? Yet another objective of the invention is to dispense the coffee without spilling. Can we write another object? Can you tell me? Yes, yes, we can write. Yes. So as many objectives you want, you can write. Right? So this is the object. An objective, it should start like this. An objective of the present invention is to prepare a drug which is an anti-cancer agent. Another objective of the present invention is to prepare a drug with a green method. Yet another objective of the present invention is to prepare a drug which is wherein the procedure is economic. So you can write 5 or 6 objectives, right? So the more the objectives, the easier it will be for the examiner to understand your invention. So after objectives, it is brief summary of the brief description of drawings. So here, what are all the drawings are there? See, in our articles also we have drawings, charts, tables, all of them. So these drawings have to be included in the last or as a separate document. These days we are uploading it as a separate document, but you can upload it with the complete specification as well. But since we are including drawings in the last, we have to describe the drawings briefly in this section. So brief description of drawings. So we will have heading for the drawing, isn't it? Under the drawing, figure 1, so and so, right? So I will write, if it is a mechanism, synthesis mechanism, I will write scheme 1, synthesis mechanism of A to B. I will write that. So here also, you will write in the drawing, figure 1, scheme 1 of preparing A to B. Same thing, the heading of the drawing will be the first one, then figure 2, figure 3, figure 4. All those drawing headings you will include in the brief description section of drawings. That's it. Only the headings you will write, figure 1, figure 2, figure 3. Of course, you will also include this paragraph. The embodiments of the invention is illustrated in accompanying drawings throughout which, so all these blah 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 you have to write because the section says that, patent rules and acts says that you have to include some legal terms or legal paragraphs so that it will look good or they will understand better or you are implying something to them. Actually, before this, you will also have to, I missed that heading, you will also have to write the summary of the invention before brief description. Summary of the invention. Briefly, in a paragraph or two, you will have to explain the summary. So, what exactly is your invention? Say, if coffee dispensing machine is the invention, then you will say, see, in an aspect of the present invention, we are talking about. So, the invention relates to a coffee dispensing machine. In another aspect of the invention, the present invention relates to a coffee dispensing machine wherein it dispenses the coffee without spillage. Like that you will write the summary briefly. Then coming to the detailed description. So in a detailed description, it should start with this paragraph. Okay, also we do have so many other paragraphs wherein you have to tell which words you are using, where you are using an and the, their importance as well, where you are using comprising, consisting. So all these words you will have to explain. And if you are using some other words which are not in the dictionary. So very recently I have written a patent for Usmania University. So they used a word called Paragamanjari. Botany people might be knowing. So that's a new word. Actually, it's not there in the dictionary. So Paragamanjari. So I got an objection thrown on my face. You did not define Paragamanjari. Actually, there is no meaning. I don't know exactly because it is taken from the Sanskrit. The inventor, the professor from botany, he did something. You can see it's there in the newspaper as well. The word Paragamanjari. So there was an objection. What is Paragamanjari? Define it. So similarly, if there are certain words, then define them in the detailed description. Put a side heading Paragamanjari and write a definition. What is Paragamanjari in the detailed description. If you are using any difficult word or anything that the examiner might not understand, then define it in the detailed description. And in the detailed description, you have to write everything related to your invention. As in, what all we write under methodology, results and discussion of an article will come here. I hope I'm getting you, right? So what all you write in your article under methodology, since I'm an academician, researcher, I can understand your brains. So that is why I'm putting it in a proper way for you to understand it better, right? So whatever you write in your methodology and results and discussion will also conclusion will come under detailed description. So in the detailed description, first you will talk about your invention, okay, complete invention, and you will also have examples. Under the examples, you will write all the studies and the results you got from those. So here you will explain the best method in which your invention can be performed, best method, and also other examples, like if you have any say activity studies, say XRD studies, or any NMR, IR, spectral studies, everything can be included under example section of detailed description. And you will also explain the drawings in the detailed description. Each drawing you have to acknowledge it, figure 1, figure 2, like that, and explain in the detailed description. Coming to the claims, this is what we don't have in provisional specification. Rest all we have, but in provisional specification, there ends. It will end at the detailed description. Of course, abstract will be there. Claims and drawings may or may not be there in the provisional specification, right? So coming to the claims, this one we don't have it in the article. So claim language you will learn in the coming sessions. So there are, I've seen the structure of the sessions and all. They are wherein you, how do you interpret the claims? What are the terms we use for claim? See, claim language is different. When you write something like advantages for your invention, outcomes for your invention, those fall under claims. But the claim language should be different. And when you write claims, you write it in a fresh page. Though your detailed description of the invention ends in the second line of the page, still you will start in a fresh page. Claims always should be written in a fresh page. And whatever your invention is, you should be able to explain properly in the claim. If you are unable to claim your invention, then it's gone. Always write a broader claim. Later on, anyways, the examiner will ask you to narrow it down, but always go for a broader claim. Okay, then for example, say we are preparing a composition. In that composition, say we are using, we can take the morning one, cumini. So we are using say 3 grams of cumini. So we will write between 1 to 5 grams of cumini we have used in the claims. Always broader claim will help us. If you narrow it down, say you are writing 3 grams of cumini, then someone will come, madam asked a doubt, can I change the concentration and write? So someone will come and write 2 grams of cumini and they will copy your invention. Yes, you can get a new invention without doing anything in the lab. You can copy somebody else's invention, change the concentration a little, and you can do activity studies, prove that this is more efficient. So always write a broader claim. Don't give any scope of copying for the other person. Then you can write, so there are 2 types of claims, dependent, independent. So the dependent claim comes after the independent claim. Dependent claim comes after the independent claim. Independent claim is the major part of your invention. Whatever you have to claim, you will claim in independent claim only. That is the first claim. Okay, the first claim is the independent claim. You have to dump everything in the independent claim. So examiner will consider only the independent claim. Whatever you claim in that is yours. Dependent claims are just to support your independent claim. Right? So always first claim in the invention is independent claim. Dependent are those which are dependent on the independent claim. And patent office allows 10 free claims. If you cross more than 10 claims in an invention, each claim will be charged separately. 320 rupees for each claim. Say I have 11 claims, then I will have to pay 1600 for the filing fees plus 320. If I have 12 claims, then I will pay 1600 plus 640. Like that. Each claim is 320 rupees extra. Don't say antena. But if you write and go on, and also our total invention, our total specification should be restricted to 30 pages. 30 pages. Again, from 31st page, it is extra chargeable. 1600 plus each page 160 rupees. You know what? Sometimes we end up paying instead of 1600. See, recently we did for bits, we paid 24,000 for specification. Our invention went up to 153 pages. So you don't tell that 1600 is less, because some inventions, see, few inventions can be described in 10 pages. Few inventions will go up to 153 pages like us, because we had so many derivatives. We have to include all the spectral data, everything for all the derivatives, so it went up to 153 pages. So 10 pre-claims and 30 pages of the specification. Limit your most of 99% of the inventions, especially educational institutes inventions, will not go beyond 30. But commercial patents for other bigger institutes, they will go beyond 30 pages. As far as I have written, only 2 inventions went beyond 30. I mean, my personal record, wherein they went up to 35, 36 pages, wherein we have so many diagrams to represent. That's it. So after claims, you will have to write the abstract. Abstract also has to be started in a separate page. Okay, clean page. If claims ends in the first page, first line, then also abstract should start in a fresh page, right? So you will have to describe how you describe the abstract in your article. Similarly, you will describe the abstract here also. So your abstract should contain your brief summary of the invention. If you are not describing everything in the abstract, I mean not all the points, then the examiner again will raise an objection. Your abstract is not fully describing your invention in a brief manner. And there is a word limit, 150 words for an abstract, less than 150 or 150. And say for example, you are writing omnibus claims. We do have claim structure, different claims you will get to know in this 5 days. So one of the claims are omnibus claims. For example, I am defining a device. Imagine this bottle is a device. Okay. If this bottle is a device, I will number this bottle as, this is, I mean, labeling the bottle. Cap will be 1, the bottom will be 2, the body structure will be 3, and the ridges in the bottle 4. Say I am labeling this, right? So in the claims also, I will write, what is my invention? I am preparing a bottle. So of course we do not claim a bottle because it is already invented. So let us write claims for this bottle. So I will write this as my invention. How do we write claim? First, I claim a bottle. Say a bottle with number, whatever number we are giving to the entire bottle. A bottle comprising a cap within brackets 1, a bottom, comma, a bottom within brackets 2, with ridges within brackets 3, and so on. Those claims are called as omnibus claims, wherein we write numbering. Okay, when we write numbering, those claims are omnibus claims. So, for chemistry, we write Marcus claims. You will learn Marcus claims. So, when we have such numbering, we can give a figure number. We can add that labeled figure as figure 1 in the drawings, and we can mention in the abstract. Under the abstract, that read this figure. Consider this figure for abstract. So that we can do. Not always, but when we have such claims. Drawings also start in a separate paper, but instead of including it in the complete specification, you can create a separate PDF for the drawings. Each page, how many drawings you can include, but you have to follow the specifications of the Act. That means top and left 4 centimeters, right and bottom 3 centimeters gap. With that gap, we can include, if it is small drawing, we can include 2 drawings. If it is a bigger drawing, we can include only 1. If it is a table, we can include the table, half of the table in one paper, rest of the half in the other paper also. We can do that, right? So each drawings will be again on a different page. It should start in a fresh page. Drawings also. Claims in first fresh page, abstract in fresh page, drawings also in fresh page. Drawings also can be in like up to 10 pages, 11 pages. It can be in any number. Each drawing should be labeled and brief description should be given in the brief description of the drawings in the specification. Swapna madam has showed you this before. So after you finish your draft, you are good to go for filing. So go to patent office, create a folder. See, you can always practice it. How to file, it's as simple as that. You register, because you can register as an applicant. We registered as patent agents. Okay, we will register as patent agent. So it will ask our license number. You will not have any license number. You will register as applicant. Yeah, we do have INPA numbers. That is our license. So in each and every page, there we will write our license number. In the draft also, we will write Dr. Radhika Vangala, agent for applicant, INPA 4737. So we will have to write after the claim, after the description, after the abstract, and each page of the drawings we have to leave our license number. Right? If you are an applicant, you will register here as an applicant. You will get login credentials. When you get login credentials, go to e-filing patents. Under comprehensive e-filing, you can go to e-filing patents and there is a manual. Every step will be explained. That will be easy. Okay, e-filing patents, you can go ahead and file your patent by yourself. Of course, later on you will have to come to us eventually. This is just to know how we do our work. We are doing, see, if I tell you correct, my father always wanted me to take MPC because I'm a BPC student aiming for a MBBS degree, but I failed my MSET and then did my BSc, MSc, PhD, and then here. So my father always wanted me to take MPC and become a software engineer so that I can happily sit under AC and work. Or during COVID times, he used to taunt me, see, if you were a software engineer, you would have worked from home and earned a 6-digit salary. Today I mock him. See, I'm earning a 6-digit salary and I'm not a software engineer who will be bored to death of their work, but still I work like a software engineer. If COVID returns, then I can work from home. I need a laptop, good internet connection, I can work from home because everything in patent office is online. Okay, for example, you are in applicant. I need something. You will have to draft, or I need a power of attorney from you. You will have to make the power of attorney, scan it and send to me. So we don't even, most of my clients, I don't know them by their faces. If my clients come and sit here also, I will not be able to recognize them because we never meet. We only talk on phones, not even video conferences. We only talk on phones, they give me work, I will file, they give me money. That's it. Done. So am I a software engineer? But see, software engineers will get bored eventually, but not patent agents because we handle a different invention today and a different one tomorrow. So we won't get bored. You can also become patent agents. Because I changed my career. I'm a PhD in hardcore chemistry. I'm a chemistry person. So I became a patent agent. So why can't you? Sorry, ma'am, if I'm going off the way. Yes. So that is the structure of patents for you. I hope you can write a patent after this. Yes, you can write. So what exactly we do in BITS? We do have IPEC. We are under IPEC, Intellectual Property Enablement and Commercialization. So under that IP is me. Commercialize IPE is me. C is in Pilani. So I sit in Hyderabad campus. So I don't really write patents for BITS because BITS portfolio is very huge. Today we have filed 500 patents for BITS, so I cannot file. Hardly we file 2 or 3 patents per month if I try to write by myself. So we file more than that. So We are in between attorneys, inventors. So we take invention from the inventors, give it to the attorneys. So big law firms work for us. We give work for the law firms, and then they file. We are in between the professors as well as the attorneys. I am being an attorney still work. Whenever an invention comes under chemistry, I try to file for bits. I did several applications for bits, but still. So this is how, see, in bits also, professors doesn't know us by our face. Everything is online in bits. You are a professor sitting somewhere in your cabin, you can file your patent and apply for a patent from your cabin. It will reach to me. I will send it to my attorney. I haven't seen my attorneys as well. I haven't seen my professors. Of course, in some gatherings like this, we will see. So it is all e-IPEC, I can say. And we do have IDFs, inventor disclosure form, wherein the professors will fill the IDFs and send it to us. We file the patents. And we do have a project from DSC called as BITS Tech, Technology Enabling Center. Even your institute can also get the Technology Enabling Center from DSC. It's a project. So there are so many tech in the country, one being at Pilani campus, BITS Tech. So what do we do there? We, how ni-msme is doing, we also file patents for the other inventors at a lower price, very lower prices. So these are all the things we offer at BITS Tech. So we file patents, designs and trademarks, and also at very low prices. So this, I don't control this. This is in Pilani campus, but since it is our motto to, what should I say, advertise everything, I'm advertising BITS Tech. So this is our BITS portfolio. So the number has changed. This slide was prepared 10-15 days ago, but the number is changed. It is 480 plus patents we filed till date, and we got 128 patents granted as BITS as the applicant. And day to day, our portfolio is increasing. Thank you all for your patience and kind listening. Again, my campus, come back to us. You have any questions? I can take. Thank you. Ma'am, if you take the coffee dispensing machine, say, so the independent claim can be, yeah, we will take this bottle only. So I've explained independent claim of this bottle. What did I explain? A bottle comprising a cap, a bottom, ridges. Say this is my simple. We won't write such simple claims, but still and tell. This is my independent claim, wherein I want to claim this bottle. Now my dependent claim will be the bottle can fill water. The bottle as claimed in claim 1. This is the dependent claim. The bottle as claimed in claim 1, wherein it can fill water from 10 ml to 100 ml. Okay, so if you don't claim, say the bottle size, it can fill 10 ml to 100 ml. Say I am claiming only for 100 ml. Then a person will come, make a smaller bottle of this only and say it fills 10 ml. That is why you will write a broader claim. A bottle which will fill up to 10 ml and 100 ml. That is my dependent claim. And third claim, the bottle as claimed in claim 1, wherein not only water, you can fill the bottle with oil, juice or anything. The bottle can be filled with anything. Because if you don't write that, there will be a person who will write a bottle for filling oil. Same bottle he will claim for filling oil. That will be your dependent claim. Yes, ma'am. Yes. Application. Yes, ma'am, but you have to approach Pilani campus. Yes, that is applicable for you as well. I can help you. Thank you all.
Careful. Good afternoon to everyone. Now it is my privilege to propose vote of thanks to Dr. Radhika Vangala Madam. Madam, thank you very much for enlightening us on different types of intellectual property rights and structure of the patent application. You told that it will be boring, but it was not like that. This is the main part where we need to focus. Thank you very much, Madam, for your inputs into this. Uh, and you also mentioned about the importance of objectives and claims in patent application, which is very essential. So thank you once again, madam, for your valuable time. Thank you, ma'am. Great, ma'am.
Dear participants, uh, we'll take for a small break and the snacks have arrived. So have some snacks and get back immediately. Even madam also had to leave. So we'll assemble very fast. Okay. The snacks have just arrived. I think they're just coming. They said only 1 minute. Okay. So let's take a break. And people who have filed patents, who have faced the difficulties in filing the patent, who have got deceived in scheduling so much of money in filing the patents, please jot down all your questions, all your doubts, so that at least these sessions are very fruitful ones. Later on, even if you want to find out also, it doesn't. See, I have one IPR agent earlier. She used to take years and years and years to get one. See, one of my good friend, not one of my one and only good friend, Professor Jyoti, who passed away last year. She used to, face a lot of struggle in, filing the patents. But fortunately, afterwards, we got introduced to another patenting agent, and he really gave a lot of good, very good service. Very good service. When people, contract faculty, are going for facing the interviews, he could do the job in just 3 to 4 weeks of time, right? Yeah, so I even invited them. See, when one patent agent could do very fast, why not others? Why some people are taking lot of time and giving n number of reasons? This has happened, that had happened. Because we're not aware what's happening behind. We have to believe what they're saying, right? So if you are aware of how things should go, then we can question them why things are not in place, right? So get awareness, get what needs to be done, what are the things required basically and additionally, and how much wisdom is required in making your product or process or design or any mark very unique one. As madam has said, it cannot be copyable. You should make such kind of measures so that even people altering few of the changes, parameters, and saying a new product, you should be, what do you say, stringent enough to see that it cannot be copyable, even when you change the parameters. Such kind of, tricky things. I say wisdom in patenting that is required to protect your IPR. Okay, so make yourself very interactive. Jot down your doubts and questions and queries and misunderstood things and unanswered things, so that we can discuss in detail. Okay, right. The next session is going to be interactive session. Madam is going to give us some hand holding. So let us be very attentive after having the snacks. Quick, let's go for break and come back.
folded. Okay, so we have gone through the patent structure and we have discussed regarding what to be included in each part of the patent structure. Okay, so now we will be discussing about the patent filing. Okay, so in India, the patent filing used to be manual, sending the hard copies to the patent office. We have patent office at 4 places. One is in Delhi, Mumbai, Kolkata, and Chennai. Okay, and head office being the Mumbai. And for all the southern states, okay, Chennai is a appropriate jurisdiction. Okay, so likewise, every state. They have to file the patent application in the appropriate jurisdiction. Okay, for North, Delhi is Delhi, and for all the southern states, Chennai is a appropriate jurisdiction. Okay, so earlier we used to file the form 1, form 2, and the form 3, form 5, and everything. Even the fee is also paid through DD or check. Okay, through the patent office. But now they have introduced a e-filing system, okay, where we can upload the documents and we can file the patent application online, okay, and we need not worry about the jurisdiction thing where we have to, which office we have to file. Once you enter the details, address details, then automatically the appropriate jurisdiction that application will be filed in that particular patent office. Okay, so we need not worry about that. And there is a link. Um, Please note down this link, IP India. How to open this escape? Huh? There is a comprehensive e-filing system. Okay, see, there is a comprehensive e-filing. So e-filing, click on e-filing patents. So to do the e-filing, we have to have certain system requirements, and also we need to have a net banking facility. We should have a digital signature, okay, and there is a user guide, okay, which is there in this. You please go through that user guide and make the settings in your system accordingly. And also you need to take the digital signature if you are applying on your own. And uh, digital signature is mandatory, otherwise you cannot file the patent application. Okay, so I'll just show you with my ID how the yeah. So this is how this e-filing portal looks like, and before that there will be a one pop-up. Okay, I'll just click on this all forms. If you want to, And this is a government site, okay, it will be always busy and sometimes it will face a lot of trouble, but keep everything ready. So we have told about the different forms, no? So you just prepare all the forms first and keep it ready. Yeah. So when you're clicking on form 1, there will be a pop-up like this. If your invention is based on any research or information on a biological resource obtained from India, prior approval from National Biodiversity Authority is mandatory before filing the patent application. Okay. So if your invention is having that, you just first need to take the NOC from the National Biodiversity Authority. Okay, you have to go to NDA website and take the NOC from them and then proceed to the e-filing. Okay, if you are not taking the approval NOC from them, then even though when your patent application is processed, during the examination there will be an objection. That time they will not grant it. Okay, so first you need to take these things, and this can be also one of the objections that can be that can form one of the ground, okay, for opposition also. So proceed to the e-filing. Okay, so here there are different types of application. Okay, conventional application, divisional conventional application, ordinary application, patent of addition, PCT, national phase application. So we have to go with the ordinary application. So as a national, as a citizen of India, we have to file just first ordinary application. Okay, these conventional applications are from the member applicants from the different countries who are the members of this convention, Paris Convention. Okay, this is one of the system through which the members will enter into the conventional state member countries, where they will have the same treatment as a citizen, how they will be treated in the as a national. Okay, that is the advantage of going with the conventional application. Okay, and there is also patent of addition, means if suppose I have filed an application, okay, after a few months I have found some modification, I feel that it is same but I little modification. Okay, so I will file a patent of addition, okay, referring to the main application which I have already filed. Okay, so there is one more application called divisional ordinary application. Okay, so every application should contain only one invention. Okay, one application, one invention, one application. Suppose if you are filing an application having two inventions, then the examiner will raise an objection, says that it has two inventions and you have to divide the application. That time you file the divisional application. Okay. So first click on the ordinary application. Click on type of specification, whether you are going for provisional or complete. Okay. Click provisional if you are going with the provisional application. Okay. And you also need to mention the number of pages. Why you need to mention the number of pages? Because the fee will be increased based on the number of pages. For the first 30 pages, there is no fee. Okay. For every additional page after 30, okay, there will be 400 rupees extra. Okay. And for the claims also, for 10 claims, it is no additional fee, but extra 11th claim if you are adding, yes, that is the reason why the fee will be calculated based on the number of pages. That is why then you need to mention this clearly. Okay, and the abstract should start from the fresh page, and it should not contain more than 250 words. Okay, and the title should be very precise and also should not include certain terms like novel patent or uh, invented product, like that. It should not, there should not be some generic things. Or yes, and drawing also should start with a fresh page. Okay, And there is a sequence listing, especially in some inventions, okay, relating to biomedical and biotechnology, pharmacy. They have certain compounds and also DNA sequences, okay, where you need to list that, okay, that also you need to mention, okay. And title of the invention, you need to write here the title of invention, okay. Address for service. This address for service is the address where you want to get the communication. Okay. Suppose you are taking the support of a patent agent. Okay. Then the address for service will be the patent agent's address, because all the communications will get to him and he will respond it. Okay. So if you want to respond for that, applicant address, know this. Okay, whenever you are filing an application, whether you want to keep your address or the attorney address. Okay, so this you need to know, because some people, what they do, they take the support for filing, and later on when there is a communication, okay, the applicant will not respond. Okay, and they don't know also what is the status of their application. So this address, say even phone number, mobile number. Mobile number is mandatory now. You will get an SMS alert also whenever there is an FER report. Okay, after the examination, the FER report will be sent to the applicant. Okay, there will be an SMS, and once you file the application also, there will be an SMS alert. Okay, so here also you can know that. Okay, and email ID, alternative email ID, and abstract should be pasted here. Detailed description and also claims. Okay, if you are suppose filing the provisional application, only you need to mention the abstract. You need to mention just a summary. There is no need of claims, no need of drawings, anything. Okay, and here you need to add the applicant details. Okay, so before I think it is not moving forward because I have not added all these details. Okay. So in the applicant details, we need to mention the applicant nationality and also the address and also email ID. Okay. Phone number. Okay. And in the inventor also email ID, email ID, and also we need to mention whether female or male. Okay. And as an applicant, there will be whether it's a startup or an SME, okay, or educational institute type, or others, okay. That also it will be the type of applicant, okay. And if the applicants and inventors are same, just you need to click on this, and automatically the details will be copied here, okay. And in case of provisional application, you need to mention this. Provisional specification relating to the invention is filled in this form, or if it is a complete specification, you need to mention this. And also Form 9 is the request for publication. Suppose you want to get the early publication, you have to put a request, okay. Along with the filing of application, you can also request the Form 9 to publish it early, and you have to fill this form and just click on this, and there is an additional fee for early publication, that is 2,500, okay. And if you want to put a request for examination along with the application, just put all the requests while filing only. Then it will be very fast. Your process, the process will be fast. Okay. Suppose if you have filed and you are not putting the request for examination, okay, and even not early publication, after 18 months it gets published, and you have to put a request, then only it will be examined. Okay. And Form 28 is in the case of a startup or an MSME. Okay. So there is a MSME Udyam registration. Okay, where MSMEs has to submit that registration, that certificate, and this is free of cost, and anybody any MSMEs, small, micro, small, medium enterprises, there is a Udyam registration portal. They have to enter all those details. They will get an acknowledgement, and within 1 week they will get an certificate, and that is free of cost. No need to pay anything, but that is a proof that their enterprise belong to micro or small. Okay, so that along with the form 28, they need to submit it. Okay, otherwise as a startup they have to get the startup recognition from DPIIT. Okay, they can also submit form 28 under startup category. Okay, because there are certain provision like fast track examination of their application, so if they submit. Okay, so that is why, and everything they have to upload in this, okay, documents. And then I'll show you the show you one document so that I'll just quickly showing because of the confidentiality. I'll not be showing in detail. Okay. So this is just provisional. Okay. So this is invention. Okay, by individual inventors. Okay. So this is relating to food drying processing methods. Okay. So like this, they have wrote a background and also objective of the inventions, and this is just a summary of the invention. Okay. This and the process. If it is there, it is mentioned. Okay. Otherwise, summary is enough. Okay, for the provisional. Okay, and form 1 will be like this. Okay, so form 1 they need to give the this is address per service and all that, and the applicant even their signatures has to be given. Okay, and the fee also, number of pages, and the fee also whatever the amount they're paying. Okay, so those details they have to give, drawings also. And in case if they are going with the power of with a patent agent, then they have to authorize me like that. Okay, so under 100 rupees stamp paper. Okay, immediately they will get an, after filing that, they will get an exam. So this is, um, after the filing, they will get an acknowledgement like this. Okay, patent number. So it will start with the year, month, and there will be some number. Okay, form 1 and the title of the invention. Okay, so like this they will be getting immediately, and this is a number where they can track the status of the application. Okay, so they have to. And where do you check the status of the application? There is a status. Okay, click on this patents and application status. If it is published, then only you can see the information. If it is not published, okay, just file the provisional application, then it is kept confidential, and it will not be processed further also. Only once you file the complete specification and it gets published, then only you can see the information, okay, into the and this patent e-register, only the granted patents, okay, information will be there. If the patent is granted, then you have to give the patent number here and just see what is the status of that patent, whether it's an active, whether the renewal fee has been paid or not. Okay, and whether this patent, because many of the companies, they actually go through the patent status, okay, because they want to see whether this patent is active or not to manufacture, whether somebody is owning that patent, okay. So they will check whether it is valid or not, whether it has been expired due to the non-renewal, okay, all that they will check and then they will proceed, okay. And there is also link for patent search, and hope you know this in past, you know. Okay, if you want to check for the Indian patents, okay, so what you can do is you just click on any of the fields, you select the field. Suppose in the title I want to use some, suppose somebody is doing some research on a particular thing, suppose I am just giving millet, okay, I am working on millet and I want to see how many patents have been applied in India with the word millet, okay, in the title, okay, I'll just click. So you can see 170 patent applications that are filed. And if you want to see who actually filed that patent application, so you can just see Department of Mechatronics Engineering. So it uh, goes with the keyword, okay. So this is a system for identifying and weighing loose item including millets. So it is a very broad, it can be used for millets and also for other things also, but they have mentioned for millets, okay, automated millet identification. So this is how you can know the things, okay, but this is only relating to India, okay, and which are published, okay. And if you want to know the other country patents, and you can check in WIPO. You know this, okay, you just search patent, search, there is a site called Patent Scope, okay, this Patent Scope, okay, search, just you give the word millets. These are all free databases, okay. You can search using the keywords, okay. There are 17,560 patent applications, okay. This is maybe huge number. You cannot go in detail each one of them, okay. So what you can do is you can combine the keywords with the classification code, okay. So there are international patent classification which is provided by WIPO, okay. So where do you find this classification? Just go through any patent. So this is international class, okay. You just click on this. First, whenever you are searching some patents, you search in Google patents, okay. See that anything is relevant or not. If it is relevant, go through that patent and see what is the patent classification code for that, okay. If it is exactly so, codes, international patent classification is given for certain technology domains, okay. If you know the exact classification code, just you can give that code, you can get all the patent applications relating to that technology, okay. So that's why if you get an accurate correct classification code, you can search by classification codes, okay. So this is mainly preparation of wine or sparkling wine. So if you're searching for any um, preparation methods, okay, so you can use this code, okay. So like that, you can search. Even USPTO, US Patent Office, has their own classification, but international classification code will be followed by all countries. Okay, so if you search by international classification code, then you will get an accurate result, and then you can check who are all there in that, who are the companies, okay, who are the people working in that area, what actually the new developments happened in that area. Okay, because whenever you're starting some research in a particular area, then if you want to know what actually the work already been done, you first do the patent search, okay, and go through these sites. Okay, it is very tedious job, because you'll get lot of hits, a lot of results. Okay, but if you know how to use this classification codes, and with a combination of keywords and classification codes, you can just get the relevant data, and then you analyze that. Okay, analyze, read those patents, then that will be helpful for your invention, also for drafting your application. Okay, how they are drafting and how they have given their inventions in a particular way, you can also draft in that similar way. That is why always go through the patent, similar patents in that area, read that first, analyze it, and then it will be very easy for you to draft the patent application. Okay. And if you don't know the classification code, just go to catchwords. Go to search. You mention here something. Maybe I'm just giving detergent. Okay. You can just check how many codes are given by them. So go through each code and see whether it is relevant or not. Okay. And like this. So soap detergents, okay, compositions of the base essentially on soap, okay, like this you can check it, okay, and whichever it is relevant, you pick up that and search with that, okay. So these are all the documents which is required. You please note, make a note of this. Okay, whenever you're filing an e-filing, these are all the things which is required to you for filing the patent application. So I'll just showing the Indian patent sample, complete specification, a foldable pen. Okay, just how you see how this format is like that. Folder title should be there, applicant name should be there. These are the prescribed format given by the patent office. You have to follow this format only. Okay, after address, this statement should be that the following specification particularly describes the nature of invention and the manner. So you have to mention background of the invention, summary of the invention, statement of the invention, brief description, detailed description, claims, and it has to be signed by the applicant or the patent agent. Okay, and you have to give the diagrams in a separate sheet. Okay, so this is a format. I'm sharing you the format where you can, this format will make you easy to draft the patent. Okay, in your area, please try to draft a patent using this format. Okay, I'll share this to Mamata madam. Okay, this will help you to draft your patent application. Please practice it in your area. Pick up some title, something, and start practicing. Okay, so each title, how the title should be there, I have clearly mentioned in this. okay, and how the field of invention should be, how the invention, field of invention, that line should start, okay, and also prior art, how it is to be there, and the objective of the invention, what are the statements that you have right in that each section. There is a format, okay, which I have developed it by reading the manual, okay. So you can also go through the manual and list out what are all the things that you need to follow. So in your area, try to practice it so that it will be very easy for you to draft and file the application. Okay. So this is how the patent certificate will be there. Once you get the grant, you will get the certificate like this. So this is the patent application which I have filed for SNR transformers. Okay. So this is how you get the certificate, and now certificate is sent through email. Okay. Earlier there should hard copy used to be posted and they get to the particular address, but now everything is online. And this is a covering letter when you, okay, so generally it gets to the address of service, okay, like this you will get it, okay. And there are two important schemes which I want to highlight, which supports the patent, this IP. One is MSME Innovative Scheme. Do you know about this scheme? No? This is a scheme under Ministry of MSME where they will support for the IP registrations. Okay. And this is a scheme which includes three components. One is innovation, incubation, and the design, and also IPR. Okay. And this is mainly for the MSMEs, okay, to enhance their competitiveness. This funding incentives are given for MSMEs. Under incubation component, the host institutes like all these universities and even the national institutes, NITs, IITs are empaneled as a host institute. Anyone ministry announces a hackathon every 6 months. Okay, so they give certain themes. If anyone having an innovative idea, they can submit through that particular portal. Okay, MSME Idea Hackathon, and you can also select the host institute where you want to get handhold or mentorship, and they will be giving a support up to 15 lakh rupees. Okay, so this is one. Component, and the second is the design component. Under design, if any MSMEs want to do some design interventions in their product, okay, they can take the support of institutes like NID, National Institute of Designs, IITs, okay, where they can get the support for the professional services. Whatever the charges that is incurred, they will be reimbursed under this. Up to 45 lakh rupees support will be given. Even the students' design ideas are also supported. 2.5 lakh rupees design, will be given for the student design ideas. Okay. And there is an IPR component. Through this, IPFC's IP facilitation centers are established. 1 crore rupees are given to the institutions to set up the IPFC center, and also there is a reimbursement for IP registration. Suppose any MSMEs who is having the Udyam registration, they have filed the patent and it got granted. Then up to 1 lakh rupees for the Indian patent and 5 lakh rupees for the foreign patent, they get the reimbursement. And for trademark, 10,000 rupees. For Indian, for industrial design registration, 15,000 rupees reimbursement will be given, but it is only after the grant. Okay, but if they want to go through the facilitation center and they want to get the support for pre-protection stage, protection stage, post-protection stage, all the services are provided by IPFC centers. Okay. So this is for IPFC where you get a 1 crore rupees grant and also for reimbursement, foreign patent 5 lakhs, domestic, and for GI 2 lakhs rupees reimbursement. Okay, like this you can get the support. Okay. Yeah, you have it Anantapur and you have it NRDC. Actually, you are going to have the MOU, no? You can also request Tirupati if there is no IPFC center, you can put a proposal. Okay? Yes, you can. Yes, but you have to show that you have to, you are serving MSME sector or you are having startups where you have supported IT. Okay? Based on those experiences, you can ask for IPFC center. Okay. And there is also a scheme under startup intellectual property. See, there is an enrollment of IP Mitra SIP facilitators. You can check it. Okay. And there are facilitators who empaneled under Startup Intellectual Property Protection Scheme, where any startup can approach these facilitators. You can have the list of facilitators here. You can just check it. See, under this facilitators, you can just check who are all there. List of facilitators, okay, who are in that particular domain area. You can take their help. Okay, only you need to bear the government fee only. Okay, professional charges will be you can take the services of these facilitators, they will get the reimbursement. Okay, so these are the list of facilitators for the startups. Okay. You can check here. Okay, and if you want to know about the scheme, you can just click on this. There is also for trademarks and also for patents. Okay, just click on this. If you want to know what is the state definition of the state startups and also what are the roles of facilitators, and there is also a list of facilitators also who are empaneled with patent office. Okay, and you can take the help of them. Okay, only government fee you need to bear. Okay. You can also apply for the IPR chair if you are not going with the, since you are an academic institution. you can go with the IPR chair. Yeah, mainly to do some research studies in IPR and also to help the academic professors filing the patents and all that. Okay, but if you are taking the grant under IPFC, you need to facilitate MSMEs, not to the academic. They will not consider. Okay. 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 No, no, there will be a notification. Okay, you go with the Ministry of HRD, I think, throughout the year. But every 6 months there will be a steering committee head chairing that. They will screen all the applications and then they will take the decision. Okay, they will call for the presentation. Whoever submitted the shortlisted applications, they will call for the presentation. And lastly, I just want to show one small video, okay? And then if you have any questions, I will take up, okay? So what did you understand from this video? And also, because we are just giving the lectures and giving all the information, but it is up to you how you take it and put the effort to succeed in that. Okay? This 5 days we will be giving all the inputs, but the thing is, you have to put into practice. Okay? There will be a challenges, hurdles coming in this, but your effort should go on. Okay? And please, whatever the is taught to you, please put into practice. And we want this impact. We just organizing the program will not help us, or it is not the objective of the ministry also. We have to show some impact also. Okay, so if you all put these inputs in somehow in your workplace or helping others, especially students or the center, disseminating this information to actually and that will be the success of this training. So I think request all of you to be serious and put effort and also disseminate this information to families and people, students, or whoever need your help. Okay. Thank you. And my contact details I will be sharing. um, Where I clicked presentation. Oh, sorry, not this one. My mail ID has been changed. I'll write down here. You just note down. Okay. మార్నింగ్ మీకు పీపీటీ షేర్ చేశాను కదా మార్నింగ్ మీకు పీపీటీ షేర్ చేశాను కదా ఏదది డౌన్లోడ్స్ నుండి ఇదా కాదు. This is my mail ID and WhatsApp number. Okay.
Once again, good evening to one and all. I take this opportunity to thank Ms. Swapna Garu for her time and sharing valuable information. And thank you, ma'am, for being with us today for the session, both in the morning as well as in the afternoon session, and for sharing a lot of your knowledge. And thank you once again for making this session interactive. Thank you, ma'am. Thank you all.
in this forward, we have more and more synergy.